Lordship may kindly see clause B.
Hmm.
Suits between private parties for the purpose of establishing any private rights, although it may be affected by any entry in any land record. Your Lordship-
Absolutely. So
Yes,
therefore,
Your-
nothing prevents the suit from proceeding.
Yes,
The
Your
suit
Lordship.
can proceed.
This
No
suit,
difficulty. Question is only whether the claim regarding fixing of boundaries of his property is barred by the suit.
yes, Your Lordship.
What is the finding of the learned
Section,
civil judge?
section 62 specifically speaks about two private, suit between two private parties, Your Lordship.
Correct.
They can
There's
claim-
nothing which stands in the way of the suit proceeding.
Yes, Your Lordship.
That is not the question. Now, what does the learned single judge say? What is the finding?
Paragraph number 4 may kindly be seen.
Nevertheless, it will not preclude the civil court from directing an inquiry or securing a report from the revenue authorities to identify the boundaries and therefore thereafter decide the case.
He's not.
Let
he's not
them,
going to give a finding or any.
Is this property that you have mentioned, the suit schedule property,
yes,
does that form part of the property that he is now claiming as a
yes,
boundary?
yes, Your Lordship.
Forms part of the same.
Same,
section
same,
of the
same
claim
property.
Hmm.
for which the suit is pending.
Hmm.
Now, this is a statutory act, which is statutory provision under the act, which I filed a representation and the Tahsildar has issued a notice calling upon them in their presence to fix the boundaries.
What is your representation in respect of the property for which you have title,
Disputed title.
disputed title?
Survey number 191, 192, 194 and 195.
It does not prohibit. Therefore, the question whether the question of title, if at all, if it is raised in a civil suit, that can be decided in the civil suit.
Let them make a necessary application before the civil court, Your Lordship,
Why?
for the fixation of boundaries.
Why? Does it always have to be?
Your Lordship,
What is your suit? That is a difficulty. What is your suit? Your suit is only a plain injunction suit.
injunction. suit.
Yes.
Your Lordship, if Your Lordship may see section 61.
In evidence, it's a different aspect.
Yes, sir.
Succeed or fail, it's a different aspect. Now, he is only exercising his jurisdiction, which is granted to him under the Karnataka land revenue.
He does not even claim title. Yes, where is your contention with regard to title in the suit? What is your contention?
Again, I submitted memo. Starts from second paragraph, Your Lordship, page number 7. Translated copy.
No pleading on, there is no pleading on
There is
title.
no pleading in the case.
There is no pleading on title.
Your Lordship, there is a division bench judgment of this honorable court, Your Lordship. Your Lordship may permit me to.
There is no declaration of title. There is no contention with regard to title.
Your Lordship may kindly allow me to refer this particular judgment of this honorable court, Your Lordship. Division bench judgment. Your Lordship may kindly see para number 10.
Para number?
10, Your Lordship.
Ah.
Seventh line, para number 10, seventh line.
Yes.
Whenever a jurisdiction, Your Lordship. It starts from whenever a jurisdiction, end of the line.
Hmm.
Whenever a jurisdiction is conferred upon a court, all necessary powers in order to effectively exercise that jurisdiction are also deemed to have been contained in that jurisdiction, Your Lordship.
Where is the power conferred on the court to decide the boundary of a property in
Your Lordship-
accordance with the title in a injunction suit, plain suit for injunction.
Yes, Your Lordship. Your Lordship, if you read section, if your Lordship may kindly say section 61, save as otherwise provided in this act or any other law for timing in force, a revenue court shall have jurisdiction to determine, decide, dispose of any matter which it is by under this act empowered to determine. Your Lordship, if your Lordship may kindly see clause 2B, A. 2A, Lordship.
Hmm.
Claim against government relating to any property appointing to any office for any service whatsoever. This suit is particularly private suit, Your Lordship,
Hmm.
between two private parties.
Hmm.
Government is not the party. If the government is party, they can proceed with that.
So, counsel, that is not the issue. It does not preclude the decision on the issue by the civil court. Absolutely nothing prevents.
Please, Your Lord.
But what prevents the consideration by the revenue authorities under 61H is the question. Nothing prevents. This will not preclude you. If, as a matter of fact, you have a contention, injunction suit, you are aware, even on possession, you can seek it.
And moreover, Your Lordship, the suit which
How will you be prejudiced by the fixation of the boundaries of his property? If you have a contention that part of that property, which he claims on the basis of his title, is in your possession, or that you have some title
Please,
to
sir.
it, those are matters you can agitate in the civil court. Nothing prevents.
moreover, the suit which the learned counsel is mentioning, the question which has been raised, Your Lord,
This
it
is
has
not the
been
same.
withdrawn, Your Lord. The suit has been withdrawn.
You withdrew the suit.
They have withdrawn the suit, Your Lord. They have filed the suit, they have withdrawn the suit.
More the reason why it should be
Yeah.
decided here.
I'm just bringing
will-
to a kind
You
of.
will also be put on notice. You will be heard. It cannot be done otherwise. Your titles will also have to be examined.
Your Lordship, they have withdrawn this suit and they have filed another suit
Hmm.
where they have not made us the parties, Your Lordship. Thus,
It's again, therefore, there is no inter se suit between you at the moment. Now, the only issue is, while fixing the boundary,
please, sir.
his title deeds will have to be looked into, your title deeds will have to be looked into. If there is any government land in between or anywhere in the vicinity, that will also have to be considered. That is all there is to it.
Please, sir.
So now, we'll say that the suit has been withdrawn. Heard. Yes, after issuing notice, after considering whatever their objections are and the title deeds in question. Heard both sides. Heard the learned counsel appearing for the appellant, the learned government advocate appearing for respondents 1 and 2, as well as learned counsel appearing from third respondent. It is submitted by the learned counsel for the appellant that the finding in the judgment with regard to finding in the judgment under appeal that during pendency of the suit, the appellant could not have approached the revenue authority seeking fixation of boundaries is incorrect in view of the provisions of Section 61 of the Karnataka Land Revenue Act. The learned counsel for the third respondent has drawn our notice to Section 62 of the Act as well.
First respondent.
First, you are the first.
Respondent number.
Sorry. No, you are the third respondent. Just a moment, sorry, sorry.
In the
Yes.
appeal, respondent number 1 year.
This is, please say, heard the learned counsel for the appellant, the learned counsel for the first respondent, as well as learned counsel, learned government advocate appearing for the other respondents. Learned counsel for the first respondent has drawn our attention to Section 62 of the Act as well, having considered the contentions advanced. We noticed that the suit in question was a simple injunction suit filed by the appellant as against the respondents here. It is submitted that the suit has subsequently been withdrawn as well. Full stop. having considered the contentions advanced, we are of the opinion that the pendency of a suit in which an injunction simpliciter is sought cannot be a ground for non-consideration of an application made before the revenue authorities under section 61. Full stop. The learned counsel appearing for the first respondent submits that the first respondent is also entitled to be put on notice and heard, and his title documents are to be examined while the application submitted by the appellant.
असलम दस्ती साहब अब नया स्टूड डाली ना हो वो क्या
Yes. What? The earlier sentence, please. Is being considered, full stop. Having considered the contentions advanced and in view of the specific provisions of section 61 and 62, we are of the opinion that though the question of title and possession is open to be considered by the civil courts, there would be no impediment to the consideration of an application for fixation of the boundaries on the strength of title by the Tahsildar concerned. In the above view of the matter, we direct that the application submitted by the petitioner is to be, by the appellant, is to be proceeded with in accordance with law. After notice to all concerned and after examining the title deeds of the of all the owners of the properties in question. Disposed of. Appeal is
Much ob-
accordingly disposed of. Four, Arvind Basappa Reddy. Change of khata belated,
Yes, ma'am.
delay in,
Yeah.
delay in seeking,
Office objection. Yes, there is a 20 years delay, my lord.
yes.
And the vendor, my vendor's vendor has accepted, my lord, the owner who is claiming, accepted it has been left out to the court, road.
The petitioners allowed writ of certiorari issue quashing the impugned order. As a consequence, the order made by the Tahsildar is revived. Revenue entries shall be restored in terms thereof within a period of 8 weeks. And further compliance report shall be filed before the registrar, failing which costs.
Yes.
15th day of November 2022. What has happened thereafter?
May I submit? Allowed entire survey, may I submit?
Money, please.
Allowed entire survey numbers 3 acres, 16 guntas, madam. Out of which 4 guntas is kharab, madam. So what remains is 3 acres,
Moment, 3 acres,
16 guntas.
out of which
4 guntas are kharab.
4 guntas.
Guntas.
Okay. Yes, therefore, what is left is 3.12.
Yes, madam.
Hmm.
Out of that, my lord, it belonged to one Jagdish and Guru Prasad, the respondents number 1 and 2 here in Manor. My lord, they executed a sale deed on in 1992-93 in favor of the
My vendor.
appellant's vendor for an extent of 3 acres, 3 guntas. My lord, in that sale deed, my lord, 9 guntas, what is remaining, was shown as road. In that sale deed,
In
road.
the first sale.
Please, my lord, it was only shown as sale deed, shown as road. My lord, thereafter in 2013, that is about 20 years later, this Jagdish and Guru Prasad approached the AC in an appeal, stating that their 9 guntas, the entire 3 acres, 12 guntas was, Hodi was executed, was made in the name of the person who had purchased it. They challenged that entry after 20 years before the AC. And the AC,
Saying that there is a 9 gunta.
9 guntas which has to come to me. So the Tahsildar was directed by the Assistant Commissioner to execute, to change the entry so far as 9 guntas are concerned. Tahsildar changed the entries in 2013-14, my lord. In MR 16 of 2013-14, 9 guntas were changed in the name of Jagdish and Guru Prasad. It was renumbered as survey number 77/5. Thereafter, that was challenged before the Deputy Commissioner by the appellant's vendor in a review petition manner. The Deputy Commissioner allowed and set aside that order, against which the respondents came up in a writ petition. They succeeded once again in the, before the learned single judge. My lord, on the last date, I was directed to verify, as per the directions of the learned single judge, why the entries are not continuing in the name of respondents number 1 and 2. My lord, I'm filing a memo. My lord, I found a number 1 and 2 so far as survey number 77/5 for the extent. These are the facts of the
Has-
case. The vendor,
As a matter of fact, been complied with the learned single judge's directions,
please, my lord.
already been complied.
Yes, my lord. It was always
You last,
And
can
we-
you turn to, yes. I repeat, my lord, 78, the page number, 10/9/92, the sale deed. In that, my lord, the operative portion, I mean, the schedule is shown at age 82, my lord. I'll read that, my lord.
Yes, 3 acres,
Details of
16 guntas.
Land, extended to 3 acres, 16 guntas. In survey number 77/1, is so and so, situated in so and so village, Atibelem, Anekal Taluk, Bangalore, urban district. Out of this portion of land acquired by road,
But
except,
for road,
yes, ma'am, except this balance remaining the land extend to 3 acres, 3 guntas. That was the only things which was sold to me.
therefore the 3 acres, 3 guntas is all that is sold.
It is given to us. I have
Only
purchased
3 acres, 3 guntas.
3 guntas.
Therefore, 3 acres, 3 guntas, there is no change.
There,
If
there's
the-
no,
if
no,
the-
no issue,
Now in the Kata also, there is no change.
no change.
So how are you aggrieved by this?
9.
It's only the rest of the property.
Which is left out to the road is the portion which they are claiming. My lord, I will no access to the places, movements. Not only me, there are other people who has to pass through. Otherwise, I would not have purchased the property itself. Because road was there, accesses. I thought it will be, I can make use of the place there. And
Just a moment.
sorry, ma'am.
This says, this is subject, of course, to the real, the sale deed in vernacular. This says out of this is the translated version says, out of this portion of land acquired for road.
Yes, ma'am.
If it is acquired for road, where is the question of changing the Khata in favor of the
My lord,
respondents?
it was not changed as per the directions of the learned single judge, my lord. Initially, when the Tahsildar was directed to change it, my lord, by the Assistant Commissioner's order, then only the entries were changed. And the entry is run in the name of respondent number 1 and 2, even as on today.
Just a moment. Where is the order of the Assistant Commissioner which directs the change?
18,
Page?
1/8. Single judge order.
No, not the
Sorry.
judge's order. I mean the Assistant Director's order.
My lord, I have the copy, my lord. It is in vernacular language. May I pass on? Ma'am?
What
147.
Yes.
My
That
lord,
is
this
it.
was passed on 3/2/2014, my lord. Anekal Taluk, Attibele Hobli, Adigondanahalli, Grama, survey number 77/1 rally, 3 acres, 16 guntas, Jamino, Pahani, Tiddupadi Bagge. So far as correction in the entries.
Version actually. English version is
No,
147, English version also.
let's read this.
My learner was reading Kannada, that's how it's very well.
Yes. Please continue.
Please, ma'am. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆನೇಕಲ್ ತಾಲೂಕು ಅತ್ತಿಬೇಳೆ ಹೋಬಳಿ ಆದಿಗೊಂಡನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 77/1ರಲ್ಲಿ 3 ಎಕರೆ 16 ಗುಂಟೆ 4 ಗುಂಟೆ ಖರಾಬು ಸೇರಿ ಜಮೀನಿನ ಪೈಕಿ 3 ಎಕರೆ 12 ಗುಂಟೆ 174/88-89 ರಂತೆ ಶ್ರೀ ಸುಬ್ಬಕ್ಕ ಓಂ ಮುನಿರಾಯಪ್ಪರವರ ಹೆಸರಿಗೆ ಪಿತ್ರಾರ್ಜಿತವಾಗಿ ಬಂದ ಆಸ್ತಿ ಆಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖದ ತಮ್ಮ ವರದಿಯಲ್ಲಿ ತಿಳಿಸಿರುತ್ತೀರಿ. ಆದರೆ 174/88-89 ರಲ್ಲಿ ಪುಟ ಸಂಖ್ಯೆ 1ರಲ್ಲಿ ಯಾವುದೇ ಆದೇಶ ಮಾಡದೆ ಪುಟ ಸಂಖ್ಯೆ 2ರಲ್ಲಿ ಸುಬ್ಬಕ್ಕ ಕೋಂ ಮುನಿಯಪ್ಪ ರವರು ಪವತಿ ಸಬೂಬು ವಾರಿಸ್ದಾರರು ಜಗದೀಶ್ ಮತ್ತು ಗುರುಪ್ರಸಾದ್ ಇವರಿಗೆ ಹೆಸರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 77/1ರಲ್ಲಿ 3 ಎಕರೆ 12 ಗುಂಟೆ ಜಮೀನು ಖಾತೆ ಎಂದು ಆದೇಶಿಸಿದೆ. ಆದರೆ 1ನೇ ಪುಟದಲ್ಲಿ 174/88-89 ಎಂದು ನಮೂದಿಸಿ ಪುಟ ಸಂಖ್ಯೆ 2ರಲ್ಲಿ ಆದೇಶ ಮಾಡಿರುವುದು ತಿದ್ದಿ ರದ್ದುಪಡಿಸಿದಂತೆ ಕಾಣುತ್ತದೆ. ಅಲ್ಲದೆ ನಮೂದಿನಲ್ಲಿ ಸ್ಪಷ್ಟತೆ ಇಲ್ಲ. ಆದ್ದರಿಂದ 174/88-89 ರನ್ನು ಮತ್ತೊಮ್ಮೆ ಪರಿಶೀಲಿಸಿ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ ಕ್ರಯ ಪತ್ರದ ವಹಿವಾಟಿನಂತೆ ಖಾತೆ ವರ್ಗಾವಣೆ ನಿಯಮಾನುಸಾರ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 128 ಮತ್ತು 129 ರಂತೆ ಕ್ರಮ ವಹಿಸಲು ಸೂಚಿಸಿದೆ. So it states that it was passed, that entry was made without any order or without any passing any order or verification, and hence it should be verified and it should be corrected. Accordingly, my lord, it was changed as I have produced in the memo, my lord. My lord may kindly look into the
Changed in the name of the,
changed in the name of Guru Prasad, the respondents number 1 and 2.
1
my
and
lord,
2.
to the extent of 9 guntas. And it was given a new survey number 77/5. So 77/1 remains 3 acres, 3 guntas, and 9 guntas was given in the name of Jagdish and Guru Prasad.
now what is your contention with regard, 3.3, there is no difficulty.
There is no dispute.
Your property.
Yes, safe.
Is in your, and it's in your name also.
Yes, ma'am.
Khata is also in your.
Correct.
The 9 guntas, that it has been retransferred to the respondents is your problem.
A road.
Because it, according to you, it
Yes,
was a road.
confined to road.
It was a road which could be used by everybody.
Yes.
Is your contention. Where is that dealt with by the London Single Judge?
Sorry, Mala.
Where is the contention dealt with? You were heard,
My position, what is given, the road.
heard
Yes, ma'am.
by the
I have
London Single
not heard. Tasildar did not hear me at all.
Were you
Sorry.
heard by-
Ma'am, sir.
before this court, you were heard.
Yes,
You were
yes,
put on notice and heard.
yes, yes.
Yes, what was your contention before the London Single Judge?
ಹದಿಮೂರ ಹೈಕೋರ್ಟ್ 18.
This is the
Yes, ma'am,
finding.
13.
The finding of the London Single Judge is the 1992 sale deed refers to only 3.3. And the rest is not there, therefore it remains in the possession and in the name of the respondents.
Correct.
That it has been formed as a road.
Correct.
My lord, that entry is only in the sale deed, my lord.
Oh, it was,
That is the entry made by the respondent number 1 and 2 while executing the sale deed. Whether it is a road or not, that issue is never there.
there is no question of any acquisition for a road.
No, my lord. It is written by them in that entry is in the sale deed only. That is the instructions given to me. There is no road as such. So 9 guntas had to go to
And-
respondent number 1 and 2.
For a civil suit.
Yes, my lord.
Mala, sorry, Mala. I simply put it, Mala, 82, you lots, I already pointed out. You lots see the bottom,
That, yes,
bottom of 82.
Hmm.
The respondent names are there. They have signed a signature,
correct, that is true.
making a road.
Which is why we are saying it's a
Yes.
matter for a civil suit. If as a matter of fact, there is a road there
Correct,
and you are entitled to use of the road going by your deed.
correct.
Then, and the further transfer in your name,
Yes, ma'am.
it's a matter for a civil suit. Whether it is a road or not, how do we decide? Because the official respondents say that there is no other acquisition for the purpose of a road.
Correct.
Therefore, now the question would be that 9 guntas, which is now in the name of the respondents, whether you can use it as a road.
Correct. Not only me, yes, Mala, me, road means, Mala, it is not accessible, as I said.
Either it is an
I-
explanatory right
I-
or it is left as a road for your use by the document.
Correct.
It's civil suit.
For that, my lord, actually, the Tahsildar should have conducted a thorough inquiry. Instead of that, what he says is in his order, there is some corrections are there. That correction has to be, at least, he has to put me also there and find out what are the issues and what are the roads are there and all that. Instead, this order is passed. Only my statement, my lord, at this stage,
Well, we can issue notice to the respondents, and if they come, probably if there is any chance of settlement, that can be explored. Otherwise, it's a matter for a civil suit.
let them come.
Only a matter
I
of
will,
civil suit.
yes, satisfy this one.
Yes. Heard the learned counsel for the appellant as well as the learned advocate appearing for this.
My lord, I'll take notice for respondent number 1 and 2.
Takes
Respondent number
notice
3 and 4.
For respondents 3 and 4. You notice to the private respondents.
With ಕೊಟ್ಟಿದ್ದೀನಿ ಇಲ್ಲ ನಿಮ್ಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ
The
ಇದೆ 9/16
appellants
ಅವರು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ
may also explore the chance of settlement of the disputes if any.
Very well, blame.
Yes, the memos are placed on record.
Please, ma'am.
The memo filed by the learned government advocate is taken on record. Yes,
after vacation ma'am.
after notice.
5, Prakash Angadi.
5, 11,
5, 11, 14 and 29 minutes, covered by judgment of issue.
yes,
And R2,
50%.
DC may be permitted to take notice. I'll take notice for the.
yes. Five, 11,
5, 11, 14, 29.
15, 20.
9.
R3, he's going to take that dispensation.
In 29, there is a 2 days delay in filing the appeal. That can be controlled.
Please, minute, I have no,
29,
I have no.
heard both sides. In view of the averments in the affidavit filed in support of the application, the delay of 2 days in filing the appeal shall stand controlled. Same marks in all the 4. Only in 29, there is a delay.
6. Manisha Kangu.
The appellant.
Section 34 dismissed, non-deposit
Here
of
for the-
75% of the amount.
My lords, I beg to appear on behalf of the appellant in the matter, my lords.
Yes,
My lords, my apologies for not being there in person today, my lords. I was scheduled to come from Chennai. My lords, I've just been given to understand by the appellant that they are unfortunately not in a position to make the payment, my lords. The company is run into severe losses and there's been no business in the company, my lords. I would like to proceed with the matter on merits, my lords. If I can just kindly seek for maybe 2 days, my lords. I'll be there in person to argue the matter in merits, my lords.
May make a submission, my lord. They have filed this appeal, taking a new grounds which were not urged in this one, all that.
all that we'll consider on the merits. Now, since they are not able to make the payment, there is no interim order. We'll
No
list
interim
it
order, that's, your lordship may observe it so that we can
in
go
view
ahead
of
with
the
the
fact that-
execution.
My lords, in fact, the execution proceeding is scheduled to be listed
Yes, my
tomorrow,
lord.
my lords. I'm
Let
only
us leave it
seeking
here.
an adjournment of maybe 2 days, my lords. I'll be there in person to argue, my lords, because I'll need some time to
No,
prepare.
my
I was
lord, this is
instructed
not
just
fair, my
yesterday.
lord. This is not fair.
Yes,
My lords,
Neither I am
I'm,
allowed to execute it, nor they are paying any amount.
my lords,
And-
I'm only
we'll
seeking,
take the matter
I'm-
immediately after holidays. Immediately after holidays, we'll give you a list.
But
We
your
cannot-
lordship
we
may
cannot
make a
execute-
mention that interim order is, please, my lord.
my
So
lords, I'm
that
only seeking
I
your
can cut-
indulgence.
My lord,
Proceed on the
their
next day.
intention is only to dodge the things. They
My
have
lords-
been dodging so many unnecessary things they take up. Not,
My lords, I'm-
neither pleaded in the, before the arbitrator,
Understand,
not in the 34.
we are in season, we are hearing the matter. We'll list it immediately after holidays. Don't precipitate it on the next date, that is all. Immediately after holidays, the matter can be taken up and heard.
It may be taken up for final hearing. not
Very
in
well, my lords.
admission.
I'll be there in person
Admission
to
will not,
argue.
because they go on taking the timing.
My
List-
lords, in fact, the
And
ED
your
is
lordship may make a mention that they are not deposited, no interim order.
List this matter for final hearing on after holidays, please give a date.
2110.
My lords, in the meantime, if the EP is listed
Chaudhary?
tomorrow, my lords, let them not precipitate, my lords. Otherwise, I'll come on Thursday and argue, my lords.
14th or
I
15th
unfortunately.
of
Yes, it cannot be heard on Thursday. This court will not have the time to hear you.
I
on
understand. I'm at your lordship's hands, my lords. My only difficulty is the EP is listed tomorrow, my lords.
Fix a date on 14th or 15th, my lord, immediately after.
2110.
Thursday. Yes,
7. Girish Kumar B.
Please,
Very great.
section 8 dismissed.
Section 8 dismissed. My lord has heard this at matter at length earlier also. There is a stay on the suit.
We'll have it on immediately after the holidays.
Very well, very well. Synopsis also has been submitted. Very
Events. Date.
2110.
2110.
great.
8 urgent. 9. Anirudh.
Yes. 35 lakhs with 18% interest.
Yes, my lord. My lord, in this matter, what happens is the appellant, my lord, engages an advocate before the commercial court. The order sheet, my lord, it says that they have filed their wakalat on 4th November. So subsequently, we are also not aware what happens. However, the advocate stops appearing in the commercial court. So they, in 2 more hearings, my lord, the order sheet is there in page number 17, if my lordships may have. Page 17 is the order sheet, my lord. My lordships can see she, VG, files wakalat for defendant and praise time. So and subsequently, my lord, the advocate stops appearing. So therefore, the court takes away the right to file a written statement, then posts for arguments and files a final order also on 15th February, my lord. Judgment is passed on 15th February. So, my lord, my only humble submission is that even 120 days had not expired since the day of filing the wakalat. Because as per commercial code, we have 120 days to file the written statement. And my lord, again, the reason for the advocate also not appearing is not the part of the advocate, partly because the patient himself, I mean, the appellant himself was hospitalized. From page number 40 onwards, I have put his medical certificates and his X-ray and all the other reports, my lord. He had a severe spondylitis. So he was also hospitalized and he's an old person, my lord. He's aged also around so on medical reasons, he was just hospitalized. '63. Notice to be issued, my lord. And my lord, meanwhile, I'm asking, as is the IA1, my lord, IA number 1, for staying the judgment and decree of the lower court, my lord, because they might have filed an execution proceeding and probably warrant will be issued against him.
Yeah.
Yes, my lord, because we have not received any notice as of now. So in the meanwhile, if it,
Will receive notice when it is filed.
yes, my lord,
Yes, issue notice.
But if it
emergent
can be
notice to
stayed-
Respondents.
obliging.
10 urgent. 11. Prakash.
They
Agri.
move for execution, please move it. We'll consider.
Oblige.
12. Siddharth B. Muchundi.
Hearing on behalf of the respondent,
Section 34 allowed.
section 34 that was allowed, what was
This
set
is
aside?
the,
What was set aside?
just a minute. IDI Limited. This
ITI
is
limit.
The case of the cinema theatre, running of the cinema
Please,
theatre.
please,
Award is set aside.
what is set aside?
LOI is found to be not a binding contract.
Yes, my lord, the LOI has to be read in terms of the tender. So there was a finding by the learned arbitrator, but he.
Where is the appellant? Yes. Yes. Section 34 allowed and the award is set aside.
Award set
On the
aside.
finding that the LOI is not a binding contract.
Please, my lord. Because the issue, my lord, it's involved is, you know, may kindly see there was a tender which was flouted. After that, my lord, the LOI came to be signed. And,
When was the tender?
My lord, the dates,
Tender dated 10/2/2017, man.
10/2/17.
Alright.
When is the LOI?
18/5/2017.
under the LOI, my lord, there's certain responsibilities are given to me. And based on that, my lord, I went ahead, my lord, took all the permissions, sanctions, everything was done. And my lord, EMD was also, my lord, received. In the LOI, my lord, there was an undertaking that they would have detailed, my lord, lease agreement will be entered into between the parties. At that point of time, my lord, the undertaking as per the LOI, my lord, it would be, my lord, 4 years, 11 months into, my lord, 4 terms. Totally, my lord, 20 years, my lord, was the understanding. Thereafter, my lord, there were certain conditions like what was the, my lord, the power which was supposed to be given by, my lord, the landlord. It was about
75 kV.
please, 160 kV originally agreed upon. Thereafter, my lord, the issue, my lord, came that, my lord, they said that instead of 20 years, we can maximum give, my lord, 5 years. Thereafter, my lord, regarding the power also, because it was a theatre, which was the AC with, my lord, about 400 seats. So, my lord, 160 kV, we could not have, my lord, reduced on that. So, my lord, further, we agreed, my lord, to operate without the air conditioning, my lord, with 45 kV also. That also compromise for my end. With regard to, my lord, the
So
period.
some kind of an in-house cinema theater?
It was theatre. It was old theatre, which was supposed to be renovated by us. It was not a very famous ITI theatre, which has not stopped operating from several years. Now, they called upon us, and there was only one person bid. It was a successful bidder. No one else applied also. Thereafter, we went ahead and took all sanctions, permissions, everything. We invested a lot of money. We have placed on record all the thing. Thereafter, they started saying, we are not agreeable to this. Their drafts were exchanged between the parties. They then came up, they are not able on certain conditions, they were not agreeable. That's the reason I had to approach. And the nature of specific performance was sought. And
What was the award?
award, may kindly see the
Claim was allowed in part.
part,
Counterclaim dismissed.
Dismissed.
Claimant is entitled to relief of specific performance, directed to execute a lease
Execute the
agreement in terms of the LOI dated 18/5/17,
And some of 40 lakhs,
40 lakhs.
well-reasoned order, considering all the aspects, and section 34, there was the scope wasn't there, to interpret, but there's a decision, taken by the discretion used by the arbitrator. I'm not holding, it's not a question, of a binding LOI at that point of time. There's a tender. In terms of the tender, the LOI is prepared. And it's consciously signed by it. Now they not come back and say that there was a competency, other things, they were not signed. And not only being signed, in terms of the LOI,
What is the specific finding on which it is overturned?
my lords will have the page number 54, my lord, 54 of the appeal memorandum. Page para number 26. In para 16 and page number 19, the learned arbitrator held that it was of relevance of notice that subclause 3 of 25 provides for execution of license agreement, and subclause 3B stipulates that the license agreement shall prevail over the tender document. On the contrary, page number 21, para 17, the learned arbitrator held that it was already emphasized. The LOI prevailed upon the tender document in the matter of giving effect to the rights and obligations of the parties under the contract. In page 23, in panel number 19, the learned arbitrator held that at the risk of repetition, it may be emphasized that the binding LOI has overriding effect and the relevant time of voluntary execution of such material document. The claimant company was admittedly incorporated.
That was another objection raised.
Please,
by
please.
them,
Please,
who were not incorporated as of the date when you bid.
please. But having
By
said
the
that,
time the LOI was executed, you had been incorporated? No.
no, it was not
Thereafter.
incorporated thereafter. But that was objection never raised for about 4 years. They went ahead, made us to spend a lot of money, take approvals. Point number 29. It is clear that there was no concluded contract inter se between interparties. So, letter of intent cannot be construed as a binding contract. No, this is the wrong finding, which is paragraph number 29 of the learned.
We only wanted to know on what material that was entered into. Reasons must be stated.
May I place the LOI and the tender documents before this court,
We can hear it on
Please,
an agreed date immediately after. So also takes notice to the.
trial court records may be called for Manoj.
And seeks time to place. Both counsel seek time to place arguments in the matter. Call for the trial court records. They're
Please, Manoj, because
relevant.
the
If you
LOI
already
and
filed
tender-
paper books, it would be not convenient, we could refer to that.
28th October.
Please.
Please. Great.
Grateful.
13, Nidhi B. The appellant, my lord.
My lord, for the respondent number 1, I undertake to file wakalat in this matter, please, madam.
Yes, learned, so-and-so learned counsel undertakes to file wakalat on respect of R1.
R1, please.
My lord, R2 to R4 are the arbitrators. Notice may be
Yes, notice to R2 to R4 is dispensed.
obliged.
List after vacation, give a listing, please. After 28. 28:10.
28. That's
Obliged.
14 urgent, 15 Manmohan PM. Here again JDA,
Yes, Lord.
32%.
Yes.
There is a supplemental agreement which is
True.
referred. Is that discussed in the
Lord,
judgment?
trial court, Lord, does not go into it in depth. Says, Lord, there are two clauses, Lord. One clause
5B.
says 5A, Lord, provides 32%.
Correct.
But if I put up construction, Lord, in the penthouse, etc., Lord, beyond third floor, Lord, he gets 3, Lord, penthouses, which in fact I gave it to him. He released them, Lord, through, Lord, supplementary deeds.
That is, does the supplementary agreement and
Yes, ma'am.
what its effect have, is it discussed by the,
Lord, there is no, Lord, detailed discussion about it. Court says, Lord, supplementary documents are executed, but ultimately says these are not penthouses, these are apartments, therefore they're entitled to 32%. That is the finding, Lord.
the supplemental agreement was to the effect that
Releasing, Lord,
if you make further,
no, Lord.
No.
Supplementary agreements, Lord, to the effect that releasing, Lord, these 3 apartments that were, Lord, or penthouses which were given, Lord, to the plaintiffs, that they said because we are unable to pay the amount, we are releasing it in your favor.
why should they pay the amount?
But what happens is they have to give deposits, Lord, BWSSB deposit, electricity deposits, Lord, etc. They had to release and they needed some funds.
For the 32%,
No, not for 32%.
for the three.
For those 3,
penthouses.
Lord, the 3 penthouses. Yes, they,
Penthouse
Lord,
or apartment?
yes, Lord. They
Whatever.
gave that and Lord, entire thing is over. No, Lord, in fact, Lord, of course, it has to come on record also, Lord, I place it on record. All these apartments are sold. Now, Lord, they're asking for us to execute, Lord, this 32% in their favor. In fact, there's an arbitration clause, but I have to concede there is no specific contention raised. I'll have to point out to the court, but there is an arbitration clause between the parties. Therefore, Lord, suit itself was not mentioned in it.
Not raise it.
Lord, I have not raised it, no doubt about it.
Notice to the respondents. Issue notice to the respondents, emergent notice to the respondents. Just immediately after,
But can I seek for stay, Lord, because
stay of
stay of the, Lord, impugned judgment and decree? But because, in fact, it has been sold, Lord, I'll have certain other consequences.
just immediate. The direction is to,
Lord, direction, Lord, this decree is to the effect that, Lord, they're entitled for 32%. And Lord, I'm supposed to, Lord, execute all these documents. I have to give them 32%. The order decree says not to deliver 32% of the super built up area. Because rest of the properties I've given it to them.
yes. Yes, will be a stay of further proceedings.
Great.
Stay of further proceedings on the basis of the decree till the next date of hearing.
Great.
16, Amit Mandigi.
That is the matter which your lordships had heard on the last occasion regarding the arbitration maintenance.
Maintainability decided by the arbitrator, is it an award?
That is
Owned
already
against-
decided, my lord, as per law. When we go before a court, maintainability has to be decided first, not at a later. So it was decided by the learned judge saying it is maintainable. Interim order granted. Where is the question of, my lord, again going into this, and he ignores the first order passed by the court,
Yes.
totally illegal.
When do we hear this?
My lord, if possible today itself, my lord, it's a very short point. In fact, there are just 2 questions that arise for consideration. Point number 1, is the impugned order of the arbitrator an arbitral award? My lords,
An award.
if it is not an award, nothing else needs to be considered. If it is an award, are there grounds made out under section 34 to interfere with that decision? My lord, these are the 2 questions that arise. If it is not an award, my lord, which is my respectful submission, because it does not dispose of any of the parties' rights and obligations. The arbitrator makes an award. We file an application under section 33, which we are entitled to do within 30 days, saying that there is one mathematical correction that you have to make. And there are certain claims of ours which have not been decided. And without those claims being decided, my lords, the job of the arbitrator is not complete. In fact, my lord, this is the second round of the arbitration.
Yes.
There is a partnership firm which has assets. Those assets will have to be disposed of. My lord, the partnership firm has been ordered to be dissolved.
Is there any chance of a settlement?
No.
Says, yes, we can list it on another day. We don't think it can be heard today.
Last week of October, my lord, because till then I'm not in the country, I'll be returning and interim order.
List it on,
Here.
on the last day,
For a date be fixed, my lord?
28th,
Very.
28th,
October.
Because I'll be returning only on 21st.
28th, 28th,
28th.
28th of October,
That's fine. I oblige, my lord. I'm interim
Yes.
order to be continued.
till then.
Highly oblige.
17. Krishna Swami as Pradeep.
Section
Switching
34.
side.
Just a moment, is 19 also connected?
Yes.
19 is connected.
But what happened, but I will explain in the.
One is section 34, one is section 9.
Section.
Hmm?
As far as section 9 is
19.
concerned, my lord,
Yes,
I had the benefit of section 17 order throughout. The arbitral award is in my favor. And another, I had a section 9 order also in my favor until the court disposed of the section 24.
section
Therefore, my lords, I am asking that I be protected, my lords, due to the
Item
pendency
19.
of
yes.
But as far as the.
Section 9 dismissed post award.
Post.
Award set aside, therefore nothing survives as the finding. Yes. 4 crore 20 lakh 51,731 with interest at 8.54%. Yes, I was a little surprised by the 8.54. As a matter.
Rounded off figure, my lords.
Yes,
It was a technical tribunal comprising of engineers. There was one lawyer on the tribunal, so my lords, I'm sure that they must have been.
correct, correct.
But as far as the main matter is concerned, what happened is this. I supplied equipment to the restaurant. They did not pay on time. In fact, my lords, they kept delaying the supplies also. The supplies were heavy. And therefore, my lords, I had to incur warehousing costs, etc., because their site was not ready. They established power, unlike supply equipment to power. So, my lords, both in consideration of the delay and the additional costs that I suffered because of having to arrange for warehousing. But we entered into a MOU. It was like a one-time settlement. So if ever comes an arbitration stage, to give them one more opportunity to pay. They said that we will pay a sum of rupees, there are two components in this MOU. The MOU is entered into on 8/2/2018. The original agreement is in 2015, 2015. So, in the MOU, what they said is, for the principal amount, we will pay you 3.66 crores. It also includes of the warehousing cost, etc. And around instead of 2.48 crores of the accumulated interest, we will pay you 1.5 crores in 3 tranches. So what they do, they default on that. So I commenced an application and I say that this is in the nature of a conditional agreement because it was all predicated upon complying with this. Since they did not comply, they were in breach. I rescinded that contract. Therefore, that contract is of lower rate. The arbitral tribunal relies upon judgments of the Calcutta High Court in various say that I am entitled to rescind within the conditional agreement, and therefore, their obligations under the previous agreement of 2015 are revived. This is the decision of the arbitral tribunal, and a very detailed reasoning has been provided. Paragraphs 112 to 119. What the trial court does, in the section 34, is all the other grounds under section 34 are rejected. On this ground, my lord, although novation is not even pleaded, neither in the statement of defense in the arbitration nor in the section 34 arbitration, he says this constitutes a novation of the contract. The MOU that has been entered into is not really anything else but a novation of the contract. Therefore, the parties' liabilities under the 2015 agreement stand extinguished, and therefore, what can only be enforced is the obligation created by the 2018 contract. And then what he does, and he says that I don't agree with the interpretation of the Calcutta judgment that the arbitral tribunal has relied upon. I am relying upon the judgment, but their interpretation should have been different. The short point is this. If there are two plausible views, in section 34 proceedings, one plausible view cannot be replaced by another. That is the short point of the judgment. The trial court record may have to be summoned, otherwise I can find a paper.
And what is the protection you sought in the section 9?
The award was in my favor. The they are obviously in a financially hazardous condition, and therefore there was the order saying that they should not dispose of any of their assets. Either they can provide an undertaking, or can be pleased to order status quo as far as their assets.
We'll hear it. We'll call for the records and hear it
Yes,
immediately after our
Yes,
vacation till such time the
No, they had the
Protection shortfall
benefit
can
of,
continue.
their benefit, my lord, they also had it earlier. I have not alienated until. At that point, they had the benefit,
Yes.
that
but,
interim order. Now they wanted to attach my entire property, their plant and machinery. That was filed, section 9 was filed under that, that was rejected.
Yes, heard both sides. Both the. Call for the lower court records and list. In the first week of November,
Or I think the same day as the previous matter, number 28.
28th,
And we will
yes.
file papers.
yes, paperwork shall be filed in the meanwhile. It is submitted by the learned counsel appearing for the respondent that the properties of the respondent will not be alienated till then. Said
18.
May I?
yes. Here also section 9,
Section 9, my lord, an interim
JDA,
pay- an interim pay was made.
refundable security deposit,
Yes. And in fact, my lord,
46% and 54%. Contention is that GPA is only with regard to 54%.
what, my lord, is the finding, my lord, in fact, the learned judge, my lord, could not have gone into it because, my lord, the learned judge says these are all the domain of the arbitral tribunal. Very importantly, my lord, after the building was constructed, insofar as the constructed area and the super built up area, my lord, the sharing was done. But documentary evidence was put before the court below to show that this is a commercial building. In fact, after the landlords, my lord, got their area of share, assigned it for the purpose of renting, my lord, finding out a tenant was, my lord, my owners. And for which even, my lord, the brokerage charges, etc. were fixed. And, my lord, depending upon, my lord, their authorization, we found a common tenant. The owners, my lord, in respect of their share, join us executing, my lord, lease deeds in favor of, my lord, a single tenant, my lord, a huge tenant, it's a building, huge building, my lord. In fact, we couldn't have found, my lord, sundry tenants because, my lord, this has to be occupied as an entire building. And they started troubling, my lord, even the tenant on a frivolous ground that there is a particular sum of our area that there is no registered lease deed in respect of that. Then, my lord, what the tenant does, tenant also would go to court seeking an order of injunction. Tenant, my lord, would get an order of injunction. My lord, I have produced it. That order, my lord, tenant also subsequently came
Because
before this honorable.
Court says that there is nothing to show that your tenants were, the tenants were, as a matter of fact, harassed.
In fact, my lord, may kindly see, my lord, the writ petition order I have produced,
Just a
where the
moment, just a
tenant, my
moment.
lord, came before this honorable court.
Just a moment with the business so and so. Further, he argued that due to misconduct of these respondents, SmartWorks for Working Spaces, which is now the tenant,
Yes.
has filed a civil suit as OS number so and so, seeking injunction. Have carefully gone through the police complaint and plaint. No doubt a police complaint has been lodged. But nowhere in the complaint, this applicant has made clear as to the dates on which these respondents interfere with the business transactions of the applicant. Further, if we peruse the plaintiff in the above suit, plaintiff never made allegation against these respondents that they are interfering with their business transaction, instead of which they sought for relief of permanent injunction against this applicant from creating third-party rights pertaining to North Tower. This is the finding.
My lord, may kindly have, my lord, page number, my lord, 554 for a moment, my lord, next year QQ, volume 2. The tenants, my lord, came before this honorable court. Tenants, my lord, in fact, it was, my lord, the storyline was the same. If my lords may kindly have, my lord, volume 2, page 554, annexed QQ. The entire story was appreciated by this honorable court. And
554.
554, my lord. The relevant portions, my lord, should kindly find on 557. I'll just read, my lord, only so much. On page number 557, the petitioner is plaintiff in so and so on the so and so court. On the ground that it's a tenant in the suit scheduled property and there is a dispute as to who is entitled to collect the rents. Petitioner here has filed OS number so and so with the following reliefs. My lord, I just skipped that. Then, my lord, page number 558, paragraph 2. Along with the original suit, the plaintiff has also filed an application under 151 CPC following for the following prayer. Then, my lord, page number 559. The petitioner and plaintiff have also filed an application under 39 rule 1 and 2 with the following prayer. Then, my lord, paragraph number 4, the trial court based upon the pleadings and the material placed before it came to conclusion it's not a fit case to grant an ex parte order, ex parte interim order, and hence passed the following order. Aggrieved by the refusal of the ex parte interim order, the present writ petition is filed on the following phrase, etc., etc. Then, my lord, paragraph number 3, my lord, on page number 560, the operative portion. Issue emergent notice. In the meanwhile, the respondents are directed to not to interfere in the peaceful possession and the enjoyment of the petitioner over the suit scheduled property. In addition thereto, the petitioner is permitted to deposit the rents payable by it before the trial court. My lord, this is the relief granted to, my lord, the common tenant. But now, a CMP is filed, my lord, and the matter has to be, my lord, thrashed out by the arbitral tribunal. My lord, two submissions, my lord. Number one, there was a clear case of dispute. Either I am correct, they are correct, my lord, that had to be, my lord, attended to by the tribunal. All that we sought in the interim, let them not disturb the tenant. That's all, my lord. In fact, I am also not in possession of the property. Admittedly, they are also not in possession of the property. A single tenant occupies the entire building.
There is already an order to that effect.
In fact, my lord, that's the reason. Now, my lord, what they are trying to interpret now, because of the dismissal of this order, once again, my lord, they have started to trouble. And the tenant, my lord, is depositing the rentals, my rentals, and as well as their rentals before the court in an interpleader suit. Therefore, my lord, minimal protection, my lord, not to, my lord, disturb during, my lord, the pendency, my lords, may kindly.
Issue emergent notice to the respondent. List immediately after service is complete. In the meanwhile,
Let them not, my lord.
already an order.
In fact, my lord, they will interpret that, my lord. They have been interpreting, my lord. They have been interpreting.
Doesn't matter. In the meanwhile, in case there is any disturbance or harassment to the common tenant, the appellant is free to place the same before this court.
So great, so
Yes.
great. So, my lords, may kindly.
We cannot assume that an order of this court will be.
My lords, may
flouted.
kindly make a note of, my lord, this order so that, my lord.
Yes.
My lords, may kindly observe that there is already, my lord, an order.
It is clear that there is already an order passed by this court that the tenant shall not be disturbed at the instance of the respondents in this appeal. Then say this last sentence.
I'm
Yes.
so greatly obliged. So great.
19 urgent 20. TB Shukmuma.
Respondent creditor on this matter.
Not even see what it says. Suit for ejectment. Please, my lord.
Judgment would have been restrained with an order passed by the trial court, as against which I am now before this court. Was lease agreement that I should use the premises for marriage hall, etc. And the trial court comes to the conclusion restraining me in that regard. The agreement speaks to that effect. I have taken my defense in the defense statement also. And
Subleasing, assigning or parting with possession in any manner
yes,
is the,
that's the order.
yes.
I can't part with the order. But using it for marriage purposes, I can't be restrained.
My lords,
You have an objection to that?
please, my lords, I do. My lords, kindly see the respondents are the owners of the property. There was an oral month-to-month tenancy. There is no written document. The written document which they allege has not been produced in this suit. In the written statement, not a single document is produced. The lease was initially for a car showroom. It was given to appellant number 2. Appellant number 1 is a firm that he has formed along with
Lease to-
appellant number 3.
A lease for a car showroom by
Yes.
oral lease?
Yes,
Month on
oral
month?
month-to-month tenancy in the year 2006 by the mother of these respondents. She has since passed away and they are her heirs. They've inherited the property. The car showroom was running. Thereafter, it has been converted into a wedding hall. For the wedding hall, a construction has been put up. My permission has not been sought. The diversion of purpose I have not consented to. On these grounds, I sought to terminate the lease in the year
No license
2023.
is required for a marriage hall?
But it was,
License.
there is a lease agreement which shows that I can use it for the purposes of.
There is no lease agreement, it's not produced. Instead, what the tenant does is, goes and files a civil suit in the trial court, City Civil Court, OS 6896 of 2022, and takes an injunction against me. I am the true owner. Then, my lords, thereafter, I filed a suit for eviction. And I issued the notice, I filed the suit for eviction. My lords, during the month of Ramzan, both last year and this year, this tenant has subleased the property to set up various stalls. In that wedding hall, they're conducting a business, in spite of an order of injunction restraining them. I have filed contempt applications which are pending because that was after the order. Therefore, my lords, now my humble submission is two things, my lords. They have to vacate. They are tenants. There is no dispute that they are tenants. My lords, if they are willing to vacate in a fixed time period, my lords, they may do so. Now the suit is posted for cross-examination of plaintiff witness, my lords, and this order has been operating since the time of the suit in 2023. And it was confirmed, my lords, in February this year. They filed it only now.
Yes.
And he as a tenant anyway cannot do any of these things. So therefore, my lords, my...
Defense at page 58 in my written statement.
Mm.
These defendants put forth the true and correct facts. What I said, defendants have constituted a partnership for mortgage.
Now, where is the tenancy agreement that you rely on?
Produce that. I'll produce
It's
it.
not produced with a written statement in the court.
Produce it.
My lords, he
Produced.
can't
Has
produce
to be, has to be
Please, my
produced there. It has to be produced before the
Produced it
trial.
there, I'll produce it here also.
It's not produced. I have filed the admissions and
Also
denials.
have produced.
In his injunction suit, he produces it. All those are concocted. And that injunction suit is stayed. I filed a memo to dismiss the suit because there cannot be an injunction against a true owner. That has been stayed by this honorable court.
Yes, learned counsel for the appellant submits that further documents which were on record before the trial court will.
My lords,
be
not in
produced
this matter,
first.
my lords, in another matter.
If it is,
Yes,
if it is not, we are not taking it up. If as a matter of fact is produced there, then we'll consider list after 2 weeks.
Please.
If my lords, your lordships may have it after vacation.
Yes, yes.
Yes, after 2 weeks.
Yes,
Very
after
well.
2 weeks will go
Very
beyond the.
I'm 2110. 21,
Yeah, date.
Chinnappa,
I
21st.
my lords. 9, Schedule C, third party rights. Marketing service agreement.
Yes, my lord, marketing services agreement wherein your lordship has directed.
Is there any point listing, passing it over today? Can we have it on some other day?
My lord, there's some urgency. We need a stay, my lords. Stay of the commercial court.
Yes.
I'll take my chance. Can you pass?
Preliminary hearing, number 22.
Matter.
Mm.
Last occasion, your lordships, after hearing the matter,
Mm.
expressed that whether there is any terms of possibility of settlement, anything.
Mm.
My lords, we intimated the parties.
Mm.
Now parties have spoken to it.
Mm.
My lords, my party did not appear.
Mm.
Now she appearing before this court
Mm.
and making an allegation that we colluded together and making an, my lords, I want to retire from this case, my lords. Party is here. She never turned up till today, my lords. Making an allegation without consulting me, my lords. My lords, this is unfair.
What is the?
Coming with another advocate.
Please, just a moment. Yes. Please tell us, is there,
ಈ ಕಡೆ ಬನ್ನಿಮ್ಮ ನೀವು ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಅಲ್ಲ
ಆ ಕಡೆ.
ಕಾಣಿಸ್ತಾ
ಬನ್ನಿ ಈ ಕಡೆ ಬನ್ನಿ.
ಮೈಕದಲ್ಲಿ ಮಾತಾಡಿ.
ಮೊಬೈಲ್ ಇದ್ರಲ್ಲಿ
Conference. ಅದಕ್ಕೆ ಏನ್ ಇದು ನನ್ಗೆ ಇವಾಗ ಅಡ್ವೊಕೇಟ್ ಮೇಲೆ ನಂಬಿಕೆ ಹೋಯ್ತು. ಅದಕ್ಕೆ ನಾನು ಕಾಂಪ್ರಮೈಸ್ ಬರಲ್ಲ. ನಾನು ಮತ್ತೆ ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡಿ ಇದು ಮಾಡಕ್ಕೆ ಸ್ವಲ್ಪ ಕಾಲ ಅವಕಾಶ ಕೊಡ್ಬೇಕು ಅಂತ.
Confidence in me. Not they want to change an advocate. I am ready to hand over the file. Till today she has not come to me, madam.
I am coming from Tamil Nadu, Hosur. I am not here. I am an aged lady. I am 63 years old.
that does not mean that we had asked whether there is any chance of settlement. It is pursuant to that you were contacted. What is your, if you don't want to settle, you can engage whoever you want and conduct the case. Don't make allegations about officers of this court. The lawyers of this court are officers of this court. Why are you making these allegations? We had asked whether there's any chance of settlement. If you don't want to settle, don't settle. Nobody's forcing you to settle any case. But don't make allegations against lawyers of this court without any material. Have you contacted the lawyer?
ಇಲ್ಲ ನಂಗೆ 10 years ಅವ್ರು ನೋಡಿದ್ದೆ.
Then why are you making these allegations? Please don't make allegations against the lawyer.
Sir,
If you don't want to settle, absolutely nobody will force you to settle. You can engage any lawyer you want. This lawyer does not want to continue with your brief. You are free to engage anybody you want, but don't make allegations against
allegation
counsel of this court.
no information from till to today.
Why did you not?
After this, they have held a settlement with all the landlords. My instructions are, that who has referred me the case. She demanded 25 lakhs per acre. They demanded,
Beyond
they are ready to pay 5 lakhs.
Whatever settlement is that they have entered into or attempted to enter into, that is not the subject matter here.
So none of the
She does
advocates
not-
were present for that settlement, my lord.
If she did not, if she does not want to settle, she can, it is open to her. Yes.
Always, my lords, I am ready to return,
Is,
my lords.
is there any allegation made against
My
you in
name-
any of
my
the
lords, no
material?
application is served to me.
Yes, don't.
Copy.
My lords, today,
Yes.
my lords, my name
The-
is removed. Let her appear first.
The learned counsel appearing for the appellant,
Appellant.
writ appellant seeks to retire from the brief and submits that the submissions made by the appellant in person who has appeared before us would make it clear that she does not want to settle the matter. In the above view of the matter, the learned counsel is permitted to retire from the brief. The writ appellant is free to engage any counsel of her choice. List after Dasara holidays.
So, my lords, later on, my lord, let her not make allegation, my lord, before any other page, my lord.
Yes.
Recorded.
It is, we make it clear that the appellant that allegations, if any, made as against the council are unjustified in the facts of the instant case. Then fix- Yes.
My name is.
Yes, you can file wakalat, anybody you want, or if you want to appear by yourself, all that. If you want to appear by yourself, you'll have to go before the party in person committee. If you want to do that, that also you can do. Otherwise, if you want to engage any other counsel, that also can be done. Now, there is no counsel appearing on your behalf. You can engage anybody you want. Yes, list after. there's a
Please.
recommendation.
Another submission also. R14. I have filed the wakalat your lordship to the advocate who was represented at that point of time. Now it seems that your lordship, that person has given instructions to my learned friend saying that I have not given the wakalat.
R20,
R14.
R14.
I am also permitted to retire from the case.
Yes, learned counsel appearing for the
R14
14th
ಅಷ್ಟೇ.
respondent is also permitted to retire from the case in view of the
ನಿಮ್ಗೆ ಕಾಪಿ ಬೇಕು ಒಂದು ಕಾಪಿ
submissions
ತಗೊಳ್ಳಿ
made
So,
before
okay,
this
okay,
court
thank you.
today.
Yes.
What's up,
List after this.
Government advocate.
Your Lordship, in the last occasion, had formally told that the appeal will be dismissed because it has become infectious. And regarding the payment, since the government has not taken any steps,
Where is the
And-
government?
there,
Just a sec. Yes. You're looking for your files? No difficulty.
only for, formally it was adjourned for dismissal. Your Lordship said on the last occasion itself,
Can it be dismissed or are you, on merits you want to make submission? We'll pass it over.
no, it is only a simple issue, Your Lordship.
What
A
is it?
direction was issued for the government to do the work. The government
You need-
followed the,
You want to argue the matter? We'll hear it. Pass over. Pass on, pass on.
That I oppose, your lordship, because this court has
We'll hear
imposed
it.
20 lakhs.
Yes.
Seeing for just filing the appeal, this court has imposed 20 lakhs for the government to deposit.
24 to 12 o'clock. We'll see whether it can be taken up. We'll see whether it can be taken up before lunch itself. Yes.
So the 24th, Sanjay Nair.
Yeah, this is the case where I was, government property was sold to me in public auction. Thereafter, they said that it has been acquired. On the last occasion, my lords, after noticing this one, my lords have recorded, as a last chance, the time is given for government advocate at her request. Otherwise, it will be ordered today. All that I am asking is, in accordance with the judgment passed by a coordinate
Bought
bench.
the property. You've had.
My
it.
lords, the auction is of the year 2007, my lords.
My lord, subsequent.
By now, even if I wanted to construct a house for myself, the purpose would have been dead by then. Though
What is the-
persons may be
What
living.
is the extent of the property?
1 acre, 12 guntas, my lords.
It is not for construction of a house.
Yes.
1 acre. 12
1 acre was for development of flats, my lords.
Yes.
What I said was purpose would be dead,
Correct,
not the persons.
correct. No, we understand. I was only saying about construction of a house. It is not.
Yes, my
1 acre, 12
lords.
guntas.
1 acre, 7 guntas, only viceroys can build, not us.
Yes.
My lord, after the order of this honorable court, my lord, I have contacted the concerned deputy commissioner. The deputy commissioner has written to the government, my lord. The government has now communicated to the deputy commissioner for refund of the bid amount of 4.5 crores.
Not
One pause, my lord, one pause. I've not yet completed. My lord, so far as the interest portion is concerned, my lord, there is no communication from the government to the deputy commissioner. May I submit the communication letters? At least it is processed, my lord. It has started. It will take a
That's,
conclusion in some time.
With regard to the interest.
Interest portion, my lord, they are,
There are two things we can do. We can wait for that decision on the.
I request so.
interest. You can take the amount.
Principal amount.
Principal amount you can take. We'll wait for the decision. I mean, we'll give them some time. If they don't, then we'll go ahead and pass orders.
Very
Now-
well, my lords. At least today let them pay 4 crore 60 lakhs.
Today to pay.
In
my lord.
addition, my lords.
How much time do
My
you?
lord, communication by the government is that I'm directed to request you to take steps to return the bid amount of 4.5 crores.
4
That-
crore 60 lakhs is the amount I have
4 crore
paid.
60 lakhs only, my lord. 4
Then
crore
why
60 lakhs.
Yeah.
10 lakhs spelling mistake while
In
speaking.
4 crore 60 lakhs is the communication, my lord.
In what time will you give?
My lord, within 4 weeks, we shall pay the principal amount, my lord. Outer limit of 4 weeks I'm asking for, my lord. It may be listed after 4 weeks, a date may be fixed, my lord.
Payment.
I shall once again persuade with the authorities with regard to the interest, my lord. If I do not get any reply, my lord, I'll leave it to this honorable court with respect to the interest. That is what I've already communicated to the authorities.
I have
That is
also,
the best we can
I
do.
have also paid, my lords. 70,785 was conversion charges for the government land after I was declared successful bidder. But kindly, it is a painful thing, my lords. I may be a builder, but that doesn't mean that the government can exploit me like this.
Yes.
And there is no consumer court also for them.
It is submitted by the learned government advocate on specific instructions and on the basis of documents which are made available before this court. That the government has granted sanction on 29/2024 to return the bid amount of rupees 4 crore 60 lakhs to the bidder. It is submitted that with regard to the incidental charges and the interest in respect of the interest on the bid amount, further instructions are awaited from the government. In the above view of the matter, and in view of the fact that permission was granted as early as on 29/2024. Yes. We direct that the principal bid amount be returned to the
Appellant.
appellant within 3 weeks from today.
Great.
The appeal shall stand posted after Dasara holidays. for the government advocate to make a last effort to get instructions with regard to the
Date
interest
will-
and incidental charges.
A
One of the
date,
last
Manoj.
week of October.
Yes, even the 28th or 28th.
Obliged.
Till then interim order be extended.
Yes, here 3 weeks, the amount.
Very,
will
very
go.
well, Manoj. I will,
4 crore 60 lakhs will be refunded within
3 weeks.
The
Because
incidental charges and
29, the,
incidental charges and
interest.
we'll say 4 weeks.
please.
4
3
weeks.
enough.
No, because we are listing it immediately thereafter. In the 4 weeks, let them pay, because 29, they've only just ordered.
Very
29.
good.
Yes.
I leave it to,
Yes,
at last I got after so many years.
yes. The rest, if you don't, get instructions, we'll direct interest. Interest has to
That
be
I've
paid.
already communicated, my lord. It's already
Yes.
communicated. The decision has to be taken by the government.
Correct. Yes.
Prashant HS.
Lords appearing for the appellants. But Lordships have already granted an absolute interim order in the matter. Matter requires consideration.
List it immediately after.
Lordships.
We'll have it immediately after the,
Contesting respondent is the BBMP Lords and private party.
26, government advocate.
25, we can have it after.
I'm not, we are government is. not-
Government advocate.
Okay. Yes, notice is served to everyone.
Notices are served, Lords. The service is complete.
Yes.
Please, Lords.
26,
In this matter, my lord, the state had taken a contention that it is within 18 kilometers radius. My lords wanted,
They said
Yes,
they will
yes.
take instruction as to what action they have taken in respect of other 64
may,
grantees.
may I file a memo, my lord? I'm filing the. I'm filing the communication. You know, that document number 1, my lord. At page number 3, the translation is at page number 10 of my memo, my lord. This is dated 7/7/2022, my lord. My lord, after the direction of the learned single judge, my lord. Thereafter, my lord, so with regard to all the other grantees, it has been referred under 108K, my lord.
Oh, it has been.
It has already been referred, my lord.
Yes.
My lord, the page number 12 onwards, my lord, is the documents which have been submitted. That is the application.
Let us just go through this.
Please, my lord. May I read, my lord?
Yes, please.
English translation, may I read?
Yes.
With regard to the above subject, Shri Maregowda, son of late M. Ramaya, has submitted an application to this office for carrying out Podi-related works of the land bearing survey number 39, Meenankunte village, Jala Hobli, Yelahanka Hobli, totally measuring to an extent of 1 acre 30 guntas, as per judgment dated 24/1/22, passed by the Honorable High Court of Karnataka in WP number 20722 of 21. Therefore, since the above said land falls within 18 kilometers, therefore it's falling within the jurisdiction of BBMP, and therefore accordingly a proposal was sent to take appropriate action under Rule 108K of the Land Revenue Rules. Therefore, as per the judgment passed by the Honorable High Court of Karnataka for taking appropriate action under Rule 108K of Land Revenue Rules for carrying out Podi-related works, the records pertaining to the original grant certificate persists page number 1 to 438. The entire records of Tippani number 1 to 10 are enclosed herewith for the kind reference. Persists of office records pertaining to original grant certificate number so and so for filing of cases under Rule 108K to be filed in the Court of Honorable Assistant Commissioner, Bangalore. They are all the other grantees. ma'am.
If you are taking action as against the other grantees after the judgment,
My lord, Rule 108K. My lord,
how can that be after the learned single judge finds
please, ma'am.
that it is belated, that nobody else has been proceeded against, and after that you're seeking to settle? Not.
Lord, but section 94A is very clear, my lord, under where the land falls under 18 kilometers of the municipal limits, my lord.
When?
My lord, that was in 1994, my lord.
Yes,
1997, this land could not have been granted. So for that reason, it is referred to the Assistant Commissioner for,
94.
please, ma'am.
What was the distance? That is also
That
considered.
was
Yes,
only up
ma'am.
to Hebad.
That was only up to Hebal. After the
Okay, my
BBMP.
lord, 1994, I don't know if it was up to Habal, I'll take instructions, my lord. But section
report is regarded
94A,
by Judge Leonard.
Is that aspect considered by the learned
Yes,
civil
ma'am.
judge?
Yes, my lord.
no, my lord,
I
that,
request you-
that it was up to Hebal was not considered, my lord.
No, that is considered.
It is
the
only,
relevant time,
my lord,
when
at
the-
the relevant time,
At the relevant time when the learned single judge was considering the issue, you had not admittedly not issued notices with regard to anybody else.
my lord, this information was also produced before the learned single
In
judge.
respect of some of the grantees, they have already ported the land.
Page number 15, my
I will
lord,
place it on
of the
record.
writ appeal papers, page number 15.
Hmm.
The learned AG has filed a memo dated 21/1/2022.
Hmm.
Last 3 lines, my lord.
Hmm.
Along with the communication made by the respondent Tahsildar to the Assistant Commissioner for cancellation of grants.
Hmm.
However, the learned counsel for petitioner submits this information is not made available.
Relevant, that is not the question. As on the date when the orders were passed, the order impugned was passed. There was nothing as regards anybody else. You've taken up this contention only with regard to the petitioner, the appellant here. I mean, the petitioner here in.
The respondent here.
The respondent here. Therefore, the learned single judge found that there is no material before this court showing the prompt action taken consequent to the circular dated 18/9/2014. That was the finding. And that pick and choose action cannot be taken. What are we considering? We are considering the correctness of the judgment of the learned single judge. As on the date when it was being considered, there was nothing to show that apart from the petitioner, anybody else had been proceeded against. You are relying on a circular dated 2014. Till 2022, you do nothing.
Yes.
That was the ground on which the learned single judge allowed. After the judgment, that you have taken some action will not make any difference.
Lord, in the last date, since I had argued, my lords are
But
directed
you
at least
cannot
to
rectify-
show documents
Correct.
whether we have initiated action against the other 64
Had
applicants.
taken action against the other 64 before the judgment of the learned single judge. If there was something, probably that could be argued, that we had taken action against others also. Even at the time when the learned single judge considered it. Not so. After the judgment, you cannot rectify what the learned single judge finds as against. Cannot be done. Cannot be relied on for the purpose.
But my lord, section 94A is very clear, my lord, within 18 kilometers radius. It's not only on the basis of circular, my lord. Circular is based on section 94A, subclause 4, my lord. My lord, that provision cannot be overcome, my lord.
Land Reforms Act.
May I read section?
Yes, please read.
Nothing in section 94A, regularization of certain cases of unauthorized occupation, constituting committee, etc. Subject to such rules as may be prescribed, the state government shall, by notification, constitute for each constituency of legislative assembly a committee consisting of such number of members not exceeding 5, of whom one shall be a member of legislative assembly for the purpose of grant land under subsection 4. Subsection 2, the Tahsildar of the concerned taluk shall be the secretary of the committee. Section 2A, if the state government may, if it is of the opinion that it is necessary to constitute one or more additional committees for the taluk for purpose of grant of land under subsection 4, consisting of such number not exceeding 5, as may be prescribed, the state government shall nominate from the members of one of them as chairman and another as secretary of the committee. When an additional committee is constituted, the deputy commissioner shall determine the jurisdiction of the committee and the additional committee and transfer the pending applications to the respective committee. Subsection 3, the committee or additional committee shall follow such other procedure. Subsection 4 is relevant, my lord. Nothing in section 94 shall prevent the committee constituted under subsection 1 or the additional committee constituted under subsection 2A, but subject to the rules as may be prescribed, if any, to grant to the person liable to be evicted under that section the land which he had unauthorizedly occupied prior to the 14th day of April 1990, hereinafter referred to as the said date, or any portion thereof, if he satisfies the prescribed conditions, including the extent of land held and unauthorizedly occupied by him, and makes within a period of 6 months from the date of commencement of the Karnataka Land Revenue Amendment Act 1990, hereinafter referred to as the Amendment Act, an application for such grant in such a form along with such fees as may be prescribed and on payment of such amount payable under subsection 5. Provided that the land so granted together with the land already held by such person shall not exceed 2 hectares of D class of land or equivalent thereto.
2 hectares.
Please, my lord. That is
Here,
under
extent is 1 acre 30 gunta.
1 acre.
1 acre.
Hmm.
Provided further that no land shall be granted in the areas lying within the limits of cities and city municipalities specified in column 2 of the table below and within the distance from such limits specified in the corresponding entries in column 3. Serial number 1, Bangalore City under Karnataka Municipal Corporations Act, 18 kilometers. My lord,
Therefore, now what we are considering is the orders dated 8/9/1994 and 22/7/1998.
please, my lord.
Therefore, it has to be within those 18 kilometers from the.
As on the
Bangalore
date
City
of the
Corporation.
grant,
As on.
the date
those
of the
dates.
grant.
Yes.
Grant was in the year on, it was granted on 11/11/1997, my lord.
11/11/19.
Please, my lord. Survey number 39, 1 acre 30 guntas, granted in 11/11/1997,
What was the distance from the
Bangalore
city
City,
limits
as on 1997.
Yes.
May I very,
I request your lordship to kindly take the internal page number 6 of the learned single judge's order.
Yes,
In the beginning itself.
yes.
Moreover, it has been submitted on facts
Hmm.
that the lands in questions were never within the restricted distance. Since in the year 1994-1998, the jurisdiction of the corporation, which was then known as Bangalore Mahanagarapalike, was only till Hebad. And whereas subsequently it has grown with the addition of many villages and the jurisdiction is now expanded much beyond what was the boundaries during the year 1994-98. All these aspects will have to be taken into consideration. On facts, the court has come to the conclusion that it was only till Hebad. Later it was expanded. Now, as on that day, it was beyond 18 kilometers.
Therefore, this writ petition stands disposed of granting liberty to the petitioner to file an application online and which shall be, the competent authority shall also take note of the.
But all that I had asked was to fix the boundaries of my land. If they want to take action, then let them
Therefore,
take.
if you have a contention that it was within 18, it is only if it is within 18 that you can proceed. You can, even though the direction is not to,
my lord,
it's
his
not
case
a
is,
positive direction.
his case is still pending.
All
my
that
lord.
the court has
Document
said, you
number
fix
2.
the boundary and
In my memo, my lord, I have produced the order sheet. Document number 2. I have produced the order sheet, my lord.
Therefore, what stands in the, there is absolutely nothing wrong in the directions now issued. How are you aggrieved? That we don't have to consider what was the extent of the Bangalore City Corporation as on that date. Just open for the, who's directed? Assistant Commissioner to make that verification.
My lord, that observation may be passed in this order, my lord, that nothing comes in the way of the case which is pending at page number 23, document number 2 of my memo, my lord. That is the case against, under Rule 108K, which is initiated against the respondent herein for cancellation of grant.
No, if as a matter of fact,
Please,
it is
madam.
within 18 kilometers.
My lord, that is a matter of
the
fact.
108K goes.
My lord, if it is a matter of fact before the assistant commissioner in this case, my lord.
Exactly.
Please, my
That is
lord.
only
If
against
that
me,
there is,
insofar as 64
There
other
are two
persons.
ways of doing this.
Please.
Either you can tell us what was the extent of the corporation as on the date when the grant happened in 1997. If that is
Well,
done, that
well,
would be the end of
In
the.
fact, the 18 kilometers to be fixed as on the date of application, not on the date of the order. There are several judgments on this point. I'll place it on record, Mela.
Either that or that issue can be looked into by the assistant commissioner. We won't say anything about the what not, because after the directions issued by the learned single judge, whatever has happened, we cannot take note. That should not be. We'll say that this will be decided on the merits after hearing the parties and considering factually what the extent was at the relevant time.
my lord,
Whether
that
it
matter is already pending, my lord. I have produced the order sheet at page number 23.
When did it become pending? When was it, when was the action taken? After the judgment of the learned single judge, we will not take note of it.
It is after the order of the learned.
We can't take note of it. After the learned single judge finds that there is no material, no action taken. Which is.
19/7/22, my lord. 19/7/2022 appeal is filed.
This is 24/1/22, the judgment.
Yes, ma'am.
Apparently as a counterblast. Cannot be, that we will not take note. It's not unfair. If we say that that will also be taken note of, it is because you had not taken any action. That the learned single judge said that there is no action as against anybody. Now you take action against everybody. We don't propose to say anything about that. This issue you can take note of.
My lord, but this case is pending, my lord, that at least it may be decided without any.
We cannot say that. Because as a matter of fact, if what is stated by the learned single judge is as a matter of fact correct, if it is beyond the 18 kilometers as on that date.
And may I take instruction so far as only that one point is concerned, my lord, whether it was within 18
This
kilometers?
is all that has been directed. That also you're free. Therefore, this writ petition stands as post of granting liberty to the petitioner to file an application online seeking 40 the duress work, and competent authority shall take action as expeditiously as possible at any rate within 3 months. Competent authority shall also take note of the observations made here and above, shall not decline to process the application contain the work.
I understand, my
To
lord.
complete the work.
This is all what has been directed. With respect to his application, we will have to produce, my lord. We'll have to proceed, my lord. But so far as our proceedings, which we have already initiated under 108K,
You had not already initiated.
I agree, my lord. Now which is initiated, my lord, which is already pending before the Assistant
First
Commissioner.
decide this and then go ahead with, if as a matter of fact, you find that it is, you can decline
That
this
shall be
application,
decided independently on merits may at least be observed, my lord.
It is only if this can be declined on the merits that the other issue arises. The cancellation of the grant arises. If as a matter of fact, you find that this has to be allowed on the facts of the case, that would be the end of the 108, I mean, your 108K applications.
My lord, that's for that reason only I have filed this appeal, my lord. I shall submit whether it comes within 18 kilometers as on the date of the application only.
The first thing you should do before issuing the notices under 108K. After the learned single judge has held this, has given these observations, issuing those notices without
Pending against this respondent before the Assistant Commissioner.
which is initiated after.
I understand, my lord, after the.
Therefore, we are saying that if you had not verified this before proceeding, that amounts to the violation of the directions of the learned single judge. Prima facie.
My lord, if Hodi Durasti application is submitted, my lord, we shall, as per the directions of this learned single judge, we shall have to consider his application, my lord.
Absolutely.
For that. My lord, my application which is pending before the Assistant Commissioner, no observation.
It's not pending at the relevant time.
It was
It
not,
is
my
what-
lord.
Therefore.
It
that-
is, proceedings are still pending. At least we may be given liberty to litigate there on the merits of the case, my lord. With regard to 18 kilometers as on the date of the
That
application.
this application as directed by the learned.
Which application?
Decide that on his application as directed by the learned single. When there are directions by this court, you cannot get over them without first, otherwise there should be a specific finding that it was as on the date of the grant or the date of the application, whichever is the relevant date, it was beyond, I mean, it was within 18 kilometers. Without such a finding, this issuance of those notices itself, according to us, is against directions of this court. You cannot sit in appeal over directions of this court and issue communications thereafter. If as a matter of fact, you have facts on your side, then it is for you to reject this application on that ground. And
I
then
understand.
proceed.
I understand.
Then proceed, not, you can't get over directions of this court by proceeding without, we will not say anything about your 108 application.
I
As
got
a
the
matter
point.
of fact, we find that they are not valid.
We shall consider his application on merits, my lord.
Must be considered on the merits. Heard both sides. In view of the averments made on both sides. We are of the opinion that the learned single judge by the judgment had only directed the consideration of the application to be made by the petitioner for made by the petitioner in accordance with law. Full stop. Though the learned government advocate relies on section 94 A,
94,
subclause
94, 3,
94 A,
94, A, 3.
94 A, 3 and 4 of
4, man, 90, Karnataka Land Revenue Act. madam.
of the Karnataka Land Revenue Act. And submits that
Subclause 4, my lord, not 3. Proviso, second proviso to subclause 4.
94 A, 4, second proviso.
Please.
In the light of the clear directions, in light of the observations made by the learned civil judge in para 7, para 6 and 7 of the judgment, we are of the opinion that the question whether the land of the petitioner was within the objectionable distance as per the said proviso is also a matter, at the relevant time, is also a matter which could be considered by the competent authority. In the above view of the matter, we are of the opinion that there is no merit in the appeal. The appeal failed, same is accordingly dismissed. The question of distance from the limits of the BBM, of the Bangalore City Corporation at the relevant time can also be considered by the competent authority in accordance with law, while considering the application submitted by the petitioner as directed by the learned civil judge.
Time frame maybe fixed, madam. Already
Time
there was a
frame.
time frame and they have.
2 months.
Please.
Yes, the respondents, I mean, the appellant shall carry out the necessary steps as directed by the learned civil judge within a period of 2 months from today.
From today.
Delay is condoned. There's a delay. We had not condoned the delay. Delay shall stand condoned. This is the final order of the appeal. Yes. Delay usual orders.
Hearing on IS, number 28.
May I please? I appear for the,
Early hearing.
yes, I have made this application.
Yes. Can we hear
I-
it on some other day?
It's a short question, very simple question.
Yes.
Matter relates to recruitment.
Yes.
The appellant is employed.
Mm.
I am unemployed. He is happy with the interim order and dragging on the matter without allowing the recruitment to take place. All that the learned single judge has done is,
Mm.
he found that the selection was vitiated by bias,
Mm.
because
Mm.
even prior to the interview, the appellant started celebrating his status as a newly recruited person, and more importantly, giving a red salute to his prospective boss. He described it. So all this material was produced. Personal bias was alleged. Official bias was also alleged. On both counts, the learned single judge has found favor with me and has set aside the recruitment and directed a fresh recruitment to take selection to take place.
Mm.
Then I was on top of the list so far as the written test is concerned. At the interview, the scales were tilted in such a way that I was reduced to 0.5%, whereas he was given.
So therefore, the learned single judge directed the selection to go on from the interview stage?
Yes,
From
yes,
the
that
interview
is,
stage?
that is all the direction.
Kindly pass over, madam, 6 pass over. Senior counsel is held up in the other.
That's all the direction issue.
Yes, pass over today.
Otherwise, your lordship speaks a date.
We'll make an attempt today itself.
Yeah,
Pass it
I'm
over,
ready.
we- After 2:30, we don't know whether it will be possible.
After
Anyway, let us
2:30,
see.
I also have a,
Can we have it on some other day?
yeah, some other day, tomorrow, day after. Because this is all the question.
Yes. But
On Friday, if it is called
difficulty is
on,
only for time.
on Friday, if it is called on Friday, there should be,
Matter of Gram Vidyut Panchayat. That GVP's matter is listed on Friday.
or Monday.
Can we have it immediately after the Dasara holidays?
My only problem is this, I am without employment and he is also placed under suspension. He can, he is already
Yep.
placed.
He also is in a hurry to
Yeah, yeah.
find out one way or the other.
In fact,
Posting on some days. We'll have it immediately after vacation. Immediately after the holidays. We
Very well.
realize the difficulty. The only problem is it must be heard.
I leave it there. I can only plead for an urgent hearing.
16th
Very well.
for preliminary hearing.
Yes, preliminary hearing. It can be disposed of at this stage.
Please be ready
Oblige.
on that. Will not be adjourned.
Please.
Yes.
Interim order make it.
Yes, still there.
Grateful.
Yes.
29 adjourn. 30.
Item 30.
Let's I appear for the, I appear for the first respondent, Millards, after vacation. Please, Millards. They may be directed to serve a copy of.
There
the
is
yes,
a
Millards.
36 days in
Please,
filing appeal.
Please,
Can
Millards.
that be condoned? And we'll.
No, Millards
list
have
it.
not been served with a copy of the IAS, Millards.
The delay continuation also you have not been. served.
No, only the appeal memorandum has been
For
served.
Arban, you are appearing.
Respondent.
This order? Accepts notice on behalf of the.
No, Millards, no. I only appear for the respondent number one. I only appear for the first
Yes,
respondent.
Private party.
Yes, issue notice.
Please, Millards.
Please serve a copy of the IAs, including that for continuation of delay. Not today comes.
Yes, notice is ordered.
Please, if you don't want, then we'll have it on some other day. Yes.
30.
If you don't want notice to be issued, we can be on some other day. Osa, yes. Yes, on some other day.
31, government advocate.
My lords.
As the matter pertains to, there's a delay in the matter, my lords.
158 days.
Madam.
Notice has to go.
My lords.
Yes, notice.
32.
46 days delay.
46 days minutes.
Notice has to go.
No, the state is on the other side. Your lordship may direct them to accept notice.
Can
All
the
only
state
instrument.
accept notice on behalf of the respondents?
My lords.
Learned government advocate?
Lords, national highways, lords, some standing down.
Lords, there will be a,
You must tell us who is the standing counsel who will accept notice. We cannot say some standing counsel. Issue notice, take out notice to the respondents. The appellant may also serve the notice by serving on the learned standing counsel.
Please.
And inform the registry so that name can be shown. Yes. Yes.
33.
I appear for the applicant.
Our Research Institute, delay. Notice has to go.
my lord, I've already, I'm appearing for the respondents. We have already filed a counter to that effect. On the last occasion, a better affidavit was filed by the appellant, my lord. On the aspect of delay, I leave.
72 days.
Yes. the better
72
affidavit
days,
is
ma'am.
Actually better.
Lord.
The better affidavit is actually better.
Yeah, we may.
Stand condone. List for admission.
Admission. My lord, interim order is there.
Remote is already there.
My lord, not to precipitate, my lord.
Lord, they have filed a stay petition.
Can
Your
we have
lordship
this-
will have to hear the.
Can we have this immediately after holidays?
Very well.
Please, till
List
that
up.
time, let them not precipitate.
May I
Holidays,
request for 28 October,
28, yes.
28.
List on 28/10
28.
for admission.
Yes, madam.
28/10 for
Very-
admission.
very-
Till such time, the further proceedings shall not be precipitated.
Please.
34, Siddharth Hitchin.
So I appear for the appellants. Senior.
31 days. Delay.
Yes.
Notice.
35, Ajesh Kumar S.
My lord, for the appellant.
34 days.
Yes, ma'am. My lord, the
Yes.
order, my lord, was passed on 28/6. We filed the appeal on 28/8, my lord. I mean, order was uploaded, certified copy was available on 28/6. 28/8, we filed it, my lord. So it was within time. Office had raised an objection. Therefore, we filed the
You appear for the respondent?
Aviator, ma'am.
Wait, we can have it on some near date.
But the
Seen the
thing is,
matter.
The matters before, the section 8,
Hmm.
defendant's appeal, application was rejected.
Hmm.
The trial court took a view, my lord, that because the lease agreement is terminated, arbitration agreement comes to an end based on a judgment prior to 1996. That's the view.
No, my lord.
My lord, this
If
is
he's
a
pressing for stay, my lord, I seek for a passover, my lord, you're being led by a senior counsel. He's held up in court all late. I request for a short passover.
No, it is not,
1 and 2. Notice to 1 and 2 ನೀವೇನ?
Now, I'm on caveat, my lord.
For both.
for both. one and
For
three.
both.
in page 49, my lord, para
Just a moment, just a moment. So,
matters tomorrow, my lord.
My lord, I just seek for a short passover. my lord.
yes,
Short passover, please,
12:34,
please,
Passover. Let's
please.
see.
Grateful.
If it's not taken up before lunch, then we'll have to,
No, my lord,
yes.
please.
36. Pa.
Niche.
I appeal for
Acquisition.
please, Miller. I appeal for the appellant. Your lordship, an interim order was granted on 29th August, subject to deposit of 50% within 6 weeks. We have communicated the same and it will be deposited by this Friday, your lordship. And the only pending application that remains is dispensation application for dispensing with the certified copy of the arbitral award at Annexure B. So, your lordship, the only issue in controversy is the nature of land. Nature of the lands, because the lands have been treated as non-agricultural. So may I just request a date for final
You have
hearing?
produced other copies. It's only the certified copy that needs to be
Needs
dispensed.
to be dispensed with. I have produced a copy because the impugned judgment, there is certified copy.
Yes.
If a date can be fixed for final hearing, the matter can be posted because
Yes.
delay has already been condoned, your lordship.
IA 1 of 2024. The
36.
IA 1 of 2024, heard both sides. The IA is allowed. List the appeal for hearing after.
Time. Dispensation allow ಆಗಿದೆ.
Listed for admission.
Ah.
Kindly list. Just after the Dasara holidays.
29th, ma'am. This one 29.
I think she means 27.
29 Sunday ಬರುತ್ತೆ.
Monday. Monday.
What is Monday? Why? What is the urgency? We'll have it after the break, 29,
21-10.
21.
21-10.
Yes.
Passed over.
Yes.
Bill number 21. Passed over matter. Then Chinappa.
My lord, please held up. So. Notice. Kindly pass. No point.
Notice. 23.
Hang on, this is the government appeal with regard to the effective date of the sixth pay commission. Now, your lordship last time asked me whether the other appeal, that is, WA 265 can be made as instructors. My humble submission is it cannot because it stems from the fact that when is the implementation of the sixth pay commission? So now we are looking into this appeal. The important issue, my lord, is if I can take your lordship to one order of your honorable lordship. To give you a brief background of the case, my lord, what has happened is in both these appeals, right from the year 2018, the learned counsel on the other side for the respondent has been making representations and filing reputations stating that there is no parity between the pay scale given to teachers under the UGC and the respondents are pharmacy professors and assistant professors coming under the AICTE, which is two different streams. So what is governed, of course, UGC and AICTE work under the same thing wherein they look into the overall as to how these colleges and technical institutions work. They only oversee.
They are pharmacy professors.
Y-
in
y-
different
Your
colleges.
lordship, may I make one correction in this? I have quoted in my other writ petition, there was a blunder in considering UGC. That in the subsequent
Is
it is AICT, I have said, because what happened is I have filed nearly 4,000 writ petitions. At that time, UGC and AICT arrears were not being paid. So by mistake, inadvertent mistake, I brought UGC into picture. And what has happened is, though the UGC and AICT arrears were to be paid as per the 6th revised pay. So there was a consent judgment to consider my representation and pass the order. The government considered my representation.
My lord,
Why in the contempt petition, I can't make any wrong submission. In the contempt, my judgment was not considered, so I instituted a contempt petition. In the contempt petition, the government clarified that they consider my representation by passing an order saying that the government will be financially overburdened to pay the money. So that I was given liberty to challenge that order. That liberty was challenged in the subsequent writ petition, and the learned single judge quashed the order passed by the government. So now, after the contempt was initiated against this thing, they filed a application to reopen the writ appeal 258, which was dismissed in the year 2020.
In
So
order to
your lordship had rightly concluded on the last occasions, since the government has considered the representation, the appeal does not survive. So your lordship wanted to dismiss the appeal because they have considered my representation. Rightly or wrongly, the representation is being considered, and even the writ appeal was also dismissed. After 3 years, they filed an application to reopen the appeal, which was dismissed. So this court had an opinion on the last occasion also to dismiss the writ appeal.
Yes, if I may just explain the background of the case, my lord. Now, if I take your lordship to 1185 of the writ appeal for a moment, the learned single judges 1185 of 2022, the writ appeal. There are two writ 58.
Your lordship, first they have to succeed in 258,
My lord,
and then they have to, because
let her argue her case, please. We'll hear
there
you.
are two writ appeals, my
Yes.
lord. One is 258, wherein it was for consideration of a representation.
Correct.
Right? We leave that aside, park it for a bit. If we look into 1185 of 2022 at 22.3, if your lordship can just take that writ appeal, my lord.
Yes.
Now, in that writ appeal, my lord, the learned single judge's order, the impugned order is at page 35. Now, over here, the learned single judge passes the impugned order. If I can read from page 49, para 3, the learned AGA, however, submits that in case some of the petitioners, the payment have been made by the state, and therefore, if the petitioners are permitted to give representation once again, the same will be considered and arrears of salaries will be paid. Then it looks into whatever the judgment, and then consequently, these writ petitions stand disposed with the specific direction to the Department of Health and Family Welfare government to pay the arrears of salary and other emoluments as per the scale fixed by the AICTE from 1/1/2006 to 31/10/2011. Now, my argument before your lordship is, we have been giving the payment as per the 6th pay commission from 1/11/2011. That is the government order which gives effect that the 6th pay commission the effective date will be 1/11/2011. However, the claim of the respondents herein is claiming arrears, that is from 1/1/2006 to 31/10/2011. My entire argument before your lordship is, this is impermissible. Firstly, because by virtue of the learned single judge's order, he hasn't set aside the government order, which was prayed for by the respondents. in this writ petition. So the mother document, that is the government order by virtue of which the implementation of the 6 Pay Commission comes into light, still holds foot. And that has been observed. My lord, if your lordship for a moment now sees the order passed by your lordship on 31/7/23 for a moment. In writ appeal 258 of 2020. Both of it have got merged because just for a moment, if your lordship sees your lordship's order dated 31/7/23. Yes. My lord, in this, from the para 4, I shall read. Per contra, learned counsel for respondent 1 and 2 would submit that pursuant to the directions issued and the directions having not been complied with, they preferred contempt petition, and in contempt proceedings, the appellants have produced an endorsement rejecting the representation, and the contempt court was pleased to close the contempt proceedings. Now they're talking about 1185. As in, sorry, this petition wherein it was considered, this 250.
By reserving liberty to the
Yes.
respondents to mount a challenge. That is what they did by filing the subsequent.
The respondent 1 and 2 are arrayed as petitioners 4 and 5 in the aforesaid writ petitions, and the learned single judge has been pleased to quash the endorsement. The learned counsel for respondent 1 and 2 would take this court to para 3 of the order of the learned single judge rendered in so and so, which reads, which I just read just now, my lord. AGA, however, submits in case petitioners, the payment has been made by the state. Therefore, if the petitioners are permitted to give a representation again, that apart, it is seen that the learned single judge has placed reliance on the ruling involving teachers who were discharging duties in technical institutions. The respondent 1 and 2 herein are teachers retired in pharmacy college. On perusal of the order, we find the notification, government order, that is a mother document, dated 17/5/2012, has not been held ultra virus, illegal, and the directions have flown independent of this notification. So there is where the learned single judge erred. And all these writ petitions that come about stems from the implementation seeking for arrears of the 6th Pay Commission.
17/5/2012 says that the arrears are to be given from what date?
Okay, now we'll go into that, my lord, the notification. The notification, my lord, if your lordship sees 1185, we have filed additional documents.
On
additional documents on 4/1/2023. 4/1/2023 in 1185. Now, in that, we have the AICT order. As in, sorry, that is from where the government order stems from this order. So I will just take your lordship through this, because your lordship last time also asked me if the AICTE is, it's the parent that looks into all this, and if the AICTE has mentioned an effective date, you have to comply with it, and that's it, period. So I'll just take your lordship through that for a moment. In that, my lord, the effective date applicability is at page 24. Now, over here, clause 3, my lord, at page 25 on top, that Roman small 3, where we are talking about applicability of the scheme. 24, 25 page.
You don't see such page numbers here.
Or we can look into, the same document is there in 256 also.
No,
56.
whichever. Yes, tell us what does it say?
Yes, I will just mention.
Yes.
So 256, it's at page 168, if your lordship finds it. Now, in that, the small, 3, it says this scheme, if your lordship could just look into it.
The scheme shall come into force.
Applicability of the scheme. At page 168. And then 169, the scheme does not extend. We are not looking at that. We are looking at the next one. The scheme may be extended. Your lordship. (169), my lord. This scheme may be extended. So the what I would like to stress on is the use of the word may be extended to all technical institutions. So it may be extended to all technical institutions. So each technical institution is different. So you have engineering, you have polytechnic, you have various.
The position is settled that
yes,
you can either accept it.
Yes, in full or not. Correct. I'm with your lordships on that. I'm just saying that there is a discretion over here for the institution to look into it and then follow it in toto.
Scheme may be extended to all technical
institutions coming under the purview of the state legislature, provided the state government wish to adopt again. So there is this discretion given. Now, my lord, after having taken your lordship through that, I would like to just take your lordship through the various government orders that emanate from the.
Is it your
UGC?
contention that you chose to accept it only with regard to technical institutions and not to pharmacy institutions?
Your lordship,
So-
may I give clarification?
Just a minute.
The thing is, under AICT, there are different technical institutions. So you have engineering, you have polytechnic, you have architecture, and you have pharmacy.
Correct.
So engineering had given it on a particular date, the effective date was a particular date. Pharmacy chose to adopt it on B particular date. But we have adopted, but the date is different. And that choosing of the date of effective date is left to the discretion of the state is my humble submission. Whether it is engineering, whether
Difficult
it's
to accept.
because
Difficult to accept because
yes,
there is the Supreme Court says on identical situations, AICT and UGC, there is a scheme.
Yes.
The scheme says that this will be the pay scales. These are the pay scales that you have to pay. 80% of the expenditure for meeting that will
Yes.
be paid by the
Center, which is
central
for a particular period only.
whatever.
Yes.
It will be paid by the center.
Yes.
You can decide whether to implement the scheme or not.
Yes.
You can decide that
Yes.
the scheme cannot be implemented. Yes. Therefore, if you're implementing the scheme, then the scheme is taken as a whole.
The scheme is taken as a whole, but
The
my
scheme-
only submission is,
When you're taking the scheme as a whole,
yes.
date of implementation also comes with the scheme.
Yes, my lord. So
The
my only
revised pay-
submission,
Just a moment.
yes.
The revised pay and revised dates of Diana's allowance under the scheme shall be effective from 1/1/2006. The revised rates of all other applicable allowances such as home rent allowance, transport allowance, children's education allowance, and non-compounded advance increments shall take effect from 1/9/2008.
Yes, my lord.
Payment
Yes.
of arrears up to 40% of the total arrears shall be made during the current financial year 2009-10. Undertaking shall be given from every beneficiary, etc., etc. Therefore, the dates on which the scheme is to be made applicable, that also is a part of the scheme.
Yes.
You cannot
No.
accept the scheme and say that we accept the scheme, but we'll get the 80%, but we will make it applicable only from subsequent dates at our discretion. That discretion is not available is what the Supreme Court has stated in several judgments.
No, my
Unless
lord.
You can tell us otherwise.
No, for instance, my lord, I have one judgment which is with regard to
I don't
UGC.
recollect judgments.
Right, no,
Oh,
no.
no. Kalyani
I know,
Madhavan,
In Kalyani Mathivanan, it was clearly said, they can't,
they cannot choose the date.
yes.
If you accept as a whole.
And even Justice Nagaratna recently has held the same, that they can't But what has happened, your lordship, since I am handling this case from a long period, what has happened is it's started with Jagdish Prasad Sharma case. In Jagdish Prasad Sharma case, what happened is there was rippling effect throughout the country. Some state implemented, some state did not implement, some state implemented before AICT passed the regulation. So in order, the government that time thought they want to gain the political gain. They said that they are given liberty to such states to either adopt or implement. But Jagdish Prasad Sharma second subsequent para said that those states which implemented AICT and UGC regulation should follow. This part was omitted unfortunately by the most of these courts single judge judgment, and now which I am taking, and the matter is now also to the Supreme Court. There is a special bench constituting on that aspect.
The only question is we cannot close it as having become infractors. We'll have to give them
Yes.
a judgment. on
No,
the
I
merits of the
just
matter.
only clarified.
Please, government advocate, please will you look into the judgments as well?
Please, I just have one and two judgments. If your lordship can just kindly look into this, because of the paucity of time, I haven't been able to do my thorough research. But however,
The questions of law in both UGC and AICT, the
Issues-
propositions are the same.
same.
It is whether you can accept piecemeal.
Yes.
Whether you
No,
can.
I'm not saying piecemeal at all,
Whether
my
you
lord.
can accept piecemeal, whether you can accept with different dates rather than what is.
So my only submission is, my lord, with
Lordship,
regard to.
may I submit one?
Yes, in that,
Jagdish Prasad.
yes, in
Yes.
that para 71. However, in the instant case, the said questions do not arise inasmuch as mentioned above, the acceptance of the scheme in its composite form was made discretionary. Therefore, there is no compulsion on the state and its authorities to adopt the scheme. The problem lies in the desire of the state and its authorities to obtain the benefit that is different. So basically, we have the
Jagdish
discretion.
Prasad was with
and-
regard to retirement age.
Right, right.
There it was found that.
Only
the
regarding age, it was.
retirement age is something for, you can either, the scheme has to be adopted in its, either
Good.
adopted or not adopted in its entirety.
Yes. So my
The question of retirement age, it was held that was something beyond the scope of the fixing of the standards of education.
Right.
It is a service matter and it is for the states to decide.
my submission, my lord, is that the implementation by the state of Karnataka with regard to pharmacy professors and assistant professors was from 1/11/2011. For UGC, it was in 2006. Now, each department, my lord, if my lord hears me out for a moment, my argument is with regard to each department, each teacher, each assistant professor, the qualification, the responsibility, the scope of work is looked into, and then the implementation of the sixth pay is given.
Cannot be.
Because UGC teachers are, it is
not us saying it. The apex court says it cannot be because where is the constitution?
Even the act says so, because the act is also, they say that it should be in total. They can't have a piecemeal. That is what your lordship has right. Even the AICT Act I can provide, which says that they can't.
Which is the entry in the, in Schedule 7.
Entry 66 and entry 25 in list 166.
Coordination, determination of standards and institutions for higher education or research and scientific and technical institutions. That is totally in the union list. Once the regulations are framed, those regulations
and
would
list two-
amount to making that an occupied field. The state government cannot deviate.
And in conflict, union government prevails. That's what even Mativannan has said. In conflicts of law between the state and
Please,
cent-
council, please, let us look into the judgments of the apex court as well. You don't have the, as far as prima facie, unless you can show otherwise.
My lord,
I don't have uh, the leeway to say that we will implement the scheme, but not from the date that the scheme says, but on a different date.
my lord,
That position appears to be covered on all fours against.
because pharmacy professors, none of them have been given this 6-pay commission.
You have to give them
But
all.
from
You have
the
to give
arrears,
all
the
of them.
arrears, the
I
arrears.
beg to correct,
We-
only in state of Karnataka it is not given.
We have
In the entire country, it is been given.
This exactly was the ground raised by most of the other states.
My
They
lord,
said
in
that
Bombay-
We have to give only with effect from the dates when it is possible for us financially to give.
Correct.
That was the content.
Please.
Found against. Tamil Nadu in Kalyani Madhivanan.
No, my lord.
Several batch of writ petitions in other judgments in respect of each state, the Supreme Court found that it is not open.
Because each state
Yeah.
has implemented it differently, my lord. The 6-pay
Your
has.
lordship, in
the same day as 2006.
your lordship, in fifth revised
Because
pay scale,
Wherever it has
instance-
been found, it has been called in question. The apex court said,
your lordship, in fifth revised pay scale, government of Karnataka has adopted same for architecture and engineering. I am producing the notification. In fifth revised pay scale,
The other important.
your lordship may
aspect-
kindly look at the fifth revised pay scale. It is uniformly implemented to engineering college and pharmacy. Only in the sixth, they have bifurcated this. In fifth revised pay scale, it was uniform. I have produced the state government order for the fifth revised pay scale, which is uniform.
his answer is on the,
This,
My lord, the learned single judge has gone on a different premise, firstly.
to please answer us on this question of law. Your contention is that
Yes.
it can be given on separate dates for
Different,
different institutions.
yes.
It appears that that is not the position. You cannot. The
Yes.
AICT regulations being statutory in nature, that is the finding. Under entry 66.
Yes.
There cannot be a leeway for the state governments to say that we will deviate even in respect of the date of application. That appears to be the position.
Please. I will have to do my research on that, my lord.
Yes.
But however, having said that, now the learned single judge has gone on a different premise totally.
Hmm.
The government order is of the year 2011.
Hmm.
Now, these respondents did not, they were sitting on the fence till 2018 and then choose to challenge it. And that hasn't been set aside. So when the government order has not been set aside, then the learned single judge's order doesn't hold any foot.
It does not have to be set aside going by the settled position of law. Please.
I will do
look
my
into it.
research on, yes.
Yes. It cannot be decided.
your
on the
lordship,
basis-
for a moment,
If
your
you-
lordship, only for a moment,
Yes.
your lordship, what my learned friend is canvassing is contrary, because during fifth revise,
Therefore, that will have to be decided and the judgment will have to be passed on that
Yeah.
aspect.
yeah, you,
She'll have to be given time to argue on the merits of
yes,
the matter.
your lordship, only I am requesting to look at the fifth revised pay scale. It was uniform. I have submitted that document to them.
Yes.
Your lordship, they are 78, 80 years, yes, a short day, because your lordship wanted to have it on third. Now at the request, it is given 23rd. Now any short date,
These are two writ appeals, and as I mentioned, it has a checkered history because whatever the learned single judges have relied on has been with regard to UGC and the implementation of the UGC pay scale to the teachers. So my lord, I took time to look into the papers, that is,
No
yes.
difference, because it is in.
But I
time
need
period.
time to do my research and effectively put forth.
After holidays, we will. Yes.
Please, my lord.
We have to hear them and pass an order.
your lordship, I am not for a moment against it. Because the court has already taken my protection. The court said that their government has deposited 20 lakhs because their only request is they may not enjoy the fruit because they are in 80s. The entire country have the benefit except,
There's a delay in 1185 of 20.
your lordship, I oppose because that appeal is not even issued notice and the court has only
Both the
tagged the
matters.
matter here and imposed cost. Now, if your lordship has to allow that, then the cost imposed, they will be having an advantage. I even notice is not been, I have not taken notice to them.
Honorable.
No, your lordship, the court was not inclined to, because the court wanted to issue, dismiss the appeal at the threshold and impose cost. Now, if I take notice, the government will get, so I am, let that matter be at the same state.
Yet to be heard.
Your lordship, let the stage be in the same state.
Submission with regard to that is that I,
Because
made your
admission
lordship
of appeal is purely discretion of this court.
31/7/2023.
Or issuing notice, I am,
Please, counsel, don't talk at once, please.
31/7/2023, the division bench took note of this and actually said, stay operating, both these matters need to be heard on merits, which I showed you.
58, we'll hear you on merits. And
But
if there is,
258, my lord, there are no proper papers and we have filed a comprehensive writ appeal with papers in 1185. Therefore, my humble submission is, this is for the state, my lord, and I understand it needs to be heard on merits.
yes.
So
will be
if
heard on-
notice is served, then both can be heard on merits, is my humble submission. And the delay may be condoned.
List on the next date. Please be ready on the
Yes.
question of law. 2310.
Yes, please, my lord.
Only 2:30. Yeah. Two matters are over. Yes, what happened to your passed over? It is not passed over. We now have only 2:30 matters left. In 2:30, we have quite a few. 2:30, we have a hearing matter also.
ನನಗೆ ಆಮೇಲೆ ಏನಕ್ಕೆ ಬೇಡ ಅಂತೀರಾ ನೀವು ನಾಮಕರಣ ಆದ್ಮೇಲೆ ಏನಕ್ಕೆ ಬೇಡ ಅವನು ಬೇಗ ಯಾವಾಗ್ಲೂ ಇದ್ರೂ ಅವ್ನು ಬೇಕೇ ಬೇಕು ಅದೇ ನೀನ್ ಹಂಗಲ್ಲ ಹೇಳ್ಕೊಡ್ತೀಯ ನೀನು ಹಂಗಲ್ಲ ಹೇಳ್ಕೊಡ್ಬೇಡ ನೀನು
My lord, this is a case where there is,
What is this?
This
This is
appeal
item.
number 35.
on Saturday, the suit was listed for the cross-examination of PW1, who has already been caught, further cross-examination of PW1. Just a minute. I just want to make one submission before my run. He was cross-examined substantially over about a month ago, 96-year-old witness. They take time on Saturday saying they want to settle the matter. And today they're pressing the appeal here. This is the height of unfairness that I can imagine. 1 minute, I have not completed. Not only that, for the last perhaps 8 years, I have not been paid a rupee. He is a tenant in my premises. Now he says arbitration, he says this, he says that.
I'm the tenant in the property. Because my application under section 8 came to be rejected, even before cross-examining the legal witness.
When was it rejected?
No, it was,
Section 8.
5/6/2024.
5/6. Now, after it came to be rejected, my lord.
And the examination, the evidence is ongoing.
No,
Yes.
evidence has started. Before the PW1 was examined, I made a submission.
List for admission on Sunday.
No, one
Yes.
submission. One
Before holidays, it will be listed for admission.
Please.
We'll see the papers also.
Lordship,
30th. 30th.
grateful.
But there's a delay, my lord. Please.
That we'll consider on that.
Please.
Madam.
Court officer?
Madam, 21. ಪಾಸ್ ಓವರ್ ಆಗಿಲ್ಲ. ನೋಟಿಸ್ ಹೇಳಿ ಕಳಿಸ್ತಿರು.
Court officer, final hearing ಮಧ್ಯಾಹ್ನ ಆಗ್ಬೋದಾ?
ನೋಡ್ಬೇಕು ಸರ್, 2:30.
Okay, thank you.